Good morning, good morning, good morning. I don't think I have ever done anything this early in the morning before. But since the jury has just arrived, been given their instructions, and gone off to start deliberating, we have no idea how quick they're going to come back. And since some of you will be anxious to know the results, I figured I would go ahead and run this morning. So while we're waiting for the verdict, we can go ahead and catch up and watch the opening statements from yesterday because we are a day behind. So let's get to it.
All right, now that we've got the technical stuff out of the way, we are back in session on State versus Ferriter. Let me have appearances, please.
On behalf of the state, Brianna Coakley. On behalf of the defense, Freedom Murad and Cora Lockett, and Ferriter is present.
Okay, all sides ready to continue with the discussion that we started yesterday afternoon regarding the jury instructions.
Yes, Your Honor, so I have made a final copy. I gave my counsel to defense. It seems like we are on the same page. Everything, I took out the burden of proof for the defense. I kept it for the state.
So here's the question I have after, and I read this very carefully and looked at it probably more than I should. But I came away after reading Radford with the feeling that in this particular case where I've limited, based on the motion for JOA by the defense, to just that prong in the information that dealt with the confinement and the caging, that did not involve bodily injury and did not involve corporal punishment, I came away with the feeling that the defense does not apply with what's left of count one, but it would apply to the lesser. And in looking at the draft of the instructions, it seems to me the defense is included both as to the charge of aggravated assault and to the lesser, but my reading of the law is that it doesn't apply now to count one.
Yep, totally forgot what I was going to do. Okay, I was going to skip ahead to opening statements and then jump back to the discussion afterwards, just in case, they get in the jury room and come back and say, like we would expect them, like we would hope they would, guilty. Okay.
Yeah.
So this is right
Yeah.
about there. Should be the state's opening statement. Good morning, Don.
All right, ladies and gentlemen of the jury, welcome back. I trust everyone had a good evening. As I advised you yesterday, the start time was later today, 1 o'clock for you folks. So that what that means is you will not be getting a lunch break. I'm presuming that you already had that before arriving. In any event, we are still in the defense portion of the case. After the defense portion of the case, we'll then be moving to closing arguments. At this point in time, does the defense have any further witnesses to call?
No, Your Honor. At this time, the defense rests and renews any previous motions for judgment of acquittal on prior grounds.
All right, court notes that the defendant has rested and renewed any previous motions filed with the court and heard by the court. At sidebar, the court's rulings with respect to all prior motions remains the same and as stated on sidebar in an open court. All right, so ladies and gentlemen, that concludes the state's and the defense portion of the case. So the evidentiary portion of this trial has been concluded. What that means for you is we will be moving in, given its closing argument.
I want to start by thanking you all for your time and attention. I know this process has been a longer one than any of us estimated, and at times, a lot of the time, it can be tedious. But this process is an important one, and the decision you're about to make is an important one. From the outside, the Ferriter family looked in a lot of ways like an ordinary family. 2 parents, 4 children, the kids go to school, there are activities, the daughters have bedrooms, normal, ordinary to the outside. But what has been established, what has been proven through the course of this case, is what was happening inside that house was anything but ordinary. We learned that, we learned that over the course of the time that was in Jupiter, Florida in December 2021 through January 2022, he was subjected to treatment by his parents, including his father, Timothy Ferriter, that was cruel, heinous, and malicious. That under or behind the facade of an ordinary family, there was the treatment and isolation, the systematic isolation and confinement of when he was 14 years old, in that room, in their garage. And that's why we're here today, because this treatment, this systemic way in which he was forced to live is a crime. Now, I want to talk specifically about the law in the case, and you just got it from the judge, but I want to talk for a few moments about some of the specifics and explain it. You heard that your job, the rules for your deliberation in this case, your duty is to determine whether or not the defendant has been proven guilty or not. It is not your job to make a determination if he is found guilty, what, if anything, the punishment should be. That role is left to the judge. And so that means that everyone in this room has a very specific job. The state has a job, the defense has a job, and the judge has a job. And you, as a jury, are here to answer the specific question: did the state prove its case beyond a reasonable doubt? And in answering that question, the law tells us that your verdict cannot be influenced by feelings of prejudice, bias, or sympathy. So if you're back there and you feel that, I feel bad for the victim, or I feel bad for the situation that the defendant is, that is not something that can influence your verdict. Now, in applying the verdict, there are three questions or three crimes at issue here. And I want to take a moment to kind of talk about each one of them. I'm going to go backwards, count 3, and then count 2, and then count 1. So count 3 in this case is child neglect. And basically, there are 3 elements that the state has to prove beyond a reasonable doubt. Elements 2 and 3 are not really in dispute in this case. The child in this case was under the age of 18 years old. He was a child. You heard that during the time period that's at issue here, he was 14 years old. And the defendant was his father. And in Florida, a person that is a father is a caregiver. So 2 and 3 are not really at issue. Now, to prove element 1, we have to show that he willfully or by culpable negligence failed or omitted to provide the care, supervision, and services necessary to maintain his physical and mental health. And we're going to go in detail, again, as we've done throughout the entirety of this case, about what the evidence, about how it shows, how it proves that there was neglect. But you heard and also from the expert witnesses in this case that they did not try to address any existing mental health issues from at least 2019 was the last time any of those were addressed by a professional. And instead, what they did was systematically isolate him and provide no treatment and have him live in a way that the experts told you would be neglectful and detrimental and abusive to any child. Now, count 2 is false imprisonment. And to prove that, we have to show that the defendant forcibly, secretly, or by threat confined or restrained RF against his will. And so, confined, imprisoned, or restrained. Here we have direct evidence of that. You can hear over and over and over again, and we went through every single day that we have on video. In the room and lock the door. The second element is that he had no lawful authority to do so. There is no lawful authority. There is no right in order to confine a child like this. That's talking about like if you're a police officer. Did you have the lawful authority to arrest someone and put them in jail? That would mean we wouldn't be able to prove that. But the defendant in this case has no lawful authority to do that in the manner that he did. And we have to prove that it was against his will, and we had his direct testimony as to that. Now, I want to talk about count 1, which is the aggravated child abuse. There are 2 elements to aggravated child abuse. The first is that he willfully tortured, maliciously punished, or willfully and unlawfully caged RF. And it's important to note here that these are ors. So it's in the alternative. It doesn't have to be all of those. It can be any one of the three. So if you find that we've proven beyond a reasonable doubt that he willfully tortured, then we've met element 1. Or instead, if you find, based on the testimony of Dr. Myers, that it's actually malicious punishment, then that is proving element 1. Or if you find that based on the circumstances and where he was kept, locked in that room day after day, that's willfully and intentionally caging, that's enough. And then we have to prove that he was under the age of 18, which there isn't much dispute here because he was 14. Now, the courts or the law gives us a definition of what malicious means, and that applies to one of those alternatives, which is malicious punishment. And that means that he wrongfully, intentionally, and without legal justification or excuse, it may be established by the circumstances. So in jury selection and opening statement, there was a lot of discussion about how do you know someone's intent. The law is that you can look to the circumstances. You can make reasonable inferences from the evidence. And it's from the circumstances from which one can conclude that a reasonable parent would not have engaged in these damaging acts towards a child for any valid reason, and that the primary purpose of the acts was to cause unjustifiable pain or injury. Now, you also got an instruction as to reasonable punishment. And in Florida, you can find the defendant guilty if you prove that we have proven beyond a reasonable doubt that the defendant was not a parent, which is not the case here, or if we've proven that the defendant's physical discipline of RF was not reasonable for misbehavior under the circumstances, not reasonable. If you find that it was not reasonable, you have to find him guilty. So I want to talk for a second about how this instruction applies to aggravated child abuse. This instruction is talking about corporal punishment, right? And we talked in jury selection about spanking a child or not spanking a child. There are circumstances in Florida where it is permissible to use corporal punishment against a child, but that has to be reasonable corporal punishment. So an example would be spanking a child.
Overruled.
Right? And so when we're evaluating whether or not this applies, about whether or not something meets the definition of reasonable corporal punishment, we look, 1, is it reasonable? And 2, is it actually corporal physical punishment, which is not the case here. Here we have intentional caging of a child, which is not corporal punishment under the circumstances. Now, you also got an instruction about lesser included crimes. And so the law is that sometimes there are crimes and then there's a lesser included crime under it. And when evaluating a lesser included crime, you start at the top. And you make a determination first, did we prove the top crime? In that case, it would be aggravated child abuse. If you found that we have proven that crime beyond a reasonable doubt, you don't need to go and look at the lesser included offenses. The same is true for child neglect, and the lesser included crime is culpable negligence. I want to talk about kind of what the lesser is really quickly on each one. The lesser included crime is child neglect, is culpable negligence. For that, you just have to find that the defendant exposed RF to personal injury, and he did so through culpable negligence. The reason why this isn't really appropriate is it's subsumed in child neglect, and this doesn't take into consideration the fact that there's a parent-child relationship here, and that the person that the action is toward is a child. This could be any adult action towards another adult. Now, as for child abuse, which is the lesser of aggravated child abuse, there has to be an intentional infliction of mental injury, or that the person committed an intentional act that could reasonably be expected to result in mental injury. So again, when we're talking about intent, how does the state prove intent? You don't have to prove, or we don't have to prove, the thoughts in someone's head. That would be impossible. But we have to prove that there was an intentional act. So this defendant made actions with intention, meaning it's not an accident. He didn't accidentally build the room in his garage. He didn't accidentally lock his child in day after day. He didn't accidentally make it so he didn't have a bathroom. That's what the types of intent mean under the law. Don't make me do it.
Well, only when you move away from the mic.
The whole time.
That's why I said give her the mic.
So, and that is what the instruction of child abuse means. So, what you have heard from the judge and what is clear is what is not an element of a crime. What is not something that we have to prove in order for you to find the defendant guilty. We do not have to prove that every minute of the day the defendant abused his son. We do not have to prove that he was subjected to that abuse at every second of the day. It can be still child abuse when there are times where you are kind and treat your child appropriately, and then other times abuse the child, which is what is happening here. We do not have to prove to you that his confinement was 24/7. There's been a lot of discussion about, well, there were times where he was let out. Absolutely. The state agrees. His sister agrees. That has always been what they have said, what they have discussed about what happened to him. It's not every moment of the day. There are lots of times where they look like an ordinary family. It's what happens behind the closed doors, which is why we're here. We do not also have to prove that the victim was starving, that he was malnourished. That has never been our contention or the state's claim. We agree that he was not clinically malnourished. The issue with the food is that they systematically controlled and regulated him to an extent where it became abusive. There was social isolation. There was lack of access. There was lack of autonomy to a level in which it was objectively harmful to any person, but specifically to. That's why the food matters. Yes, he got dinner. He got breakfast most days. You can see on the video there's 1 or 2 days that as a punishment he does not get dinner. But we sat here and watched him over and over and over again eating his meals alone in his room. It also is not a legal defense that a child has some type of diagnosis, a mental health issue, a substance abuse issue, a behavioral problem. You know, whether or not a child is born with a mental health issue or an intellectual disability or a behavioral problem, or an adopted child has those things because of trauma, because of genetics, because of a roll of the dice, that could happen in any case, adopted or biological. That is not a reason or a justification to abuse a child. And that's what the law is. And that's why you're not going to see that in an instruction that it matters at all. It is also not a legal defense that a child has behavioral problems. It's not a legal defense that it was hard, it was difficult, it wasn't as easy as the other children. It's not a legal defense that we tried other things. There's no justification legal for what happened here. It's also not a legal defense that we did not get good advice. Now, you're going to get the form in the form of the verdict. There's actually 3 counts, but I just showed 2 here. And I want to make clear that you make a determination, you just check one of these, but your determination on one charge can be different. So that means that you can find him guilty of one charge and not guilty for another. The evidence applies to all of the charges, but your determination doesn't have to matter. And some people get worried that it's going to be like on TV and the foreperson is going to have to read it out. That's not how it works in here. The clerk will read it. And this is the kind of the instruction that tells you that law that I just
want to say that was my biggest fear when I was on jury duty and I was the foreperson, that I would have to read it out and say the guy's name and then he would target me. Irrational, but still.
talked about, that a finding of guilty or not guilty as to one crime doesn't have to affect your verdict as to the other. Now, there is one instruction here that we haven't talked about a lot at all, and it's called the principal instruction. And you probably noticed that we have presented evidence of both actions and statements made by Timothy Ferriter, and also actions and statements that were done by Tracy Ferriter. And that's because although they're being tried separately, they're both charged. And so that means in cases like that, If the defendant helped another person or persons commit or attempt to commit a crime, the defendant is a principal and must be treated as if he had done all the things the other person did. So they're co-defendants and can be jointly responsible for that action. So you don't have to, in your deliberations, make a separation between who did what. They are acting together in this criminal acts. Now let's talk specifically about the evidence that has been presented. First, you had the testimony of RF, and he testified, and one of the first things that he told you and that I asked him about is how he felt about the treatment by his parents. And he told you that he found that treatment to be dehumanizing. He did not want to live in that structure in the garage, and that the defendant forced him against his will. I asked him, well, what would have happened if you refused to go in the room? And he told you that he would have been physically forced to enter that room. He would have been dragged against his will. He also told you that although he did not spend all time in that room, he did spend large portions of his day confined in that room. He told you that every single night he would be locked into the room without access to a bathroom, that there were large portions of the day where he would be locked in. Occasionally, a time or two, he would return from school, be put in, and be not let out until the next day. He would eat many of his meals alone in the room, and there was periods, more than once, where he was in the dark during the day. And, you know, on cross-examination, and also told you that, yes, it's true, he can remember the good times because their abuse of him wasn't absolute, but what their actions taught him. They taught him that his needs, personal, social, physical, did not matter. They taught him, they reinforced that he was bad and that the cruel and inhumane treatment is what he deserved. They taught him that it was his fault, that he deserved this treatment. And we can still see the impact of those lessons on Ronan today. It was apparent when he testified that those lessons, what the defendant's treatment did to him, are still there. And we see that those lessons haven't faded. And we could see that in some of the statements that he made. You could see that despite cruel, inhumane, systemically bad, harmful treatment, despite that, those people, the defendant, are still the only parents that he's ever known. That he still wants to please them.
Objection, facts not in evidence, and proper argument.
Overruled.
For a child, and you heard it from both Dr. Myers and Dr. Rappa, for a child, this type of behavior can be normalized. It's complex. It's confusing to have the people, the only people in the world that you are supposed to love and trust, to systemically treat you this way. And so for him, from today, as a 16-year-old, still a child, he needs to call it a mistake and say that they should be forgiven. But that's not what the law is. The law, when we look, Karen, sorry, did it again. When we look, we see that this was a systemic, harmful, cruel action by those people that he loved and he trusted. And under the law, it's something that's called child abuse. Now, in evaluating the testimony, we also have the testimony of his older sister, who is now 17 years old. And so when this was happening, she was about 15, 16 years old for the time in Florida. And in that white box is one of the instructions you got, and it's about evaluating the credibility of witnesses. And in evaluating the credibility, one of the things that we look at is, does the witness's testimony agree with the other testimony and other evidence in the case?
Ms. Coakley, carry the mic.
I never wanted to be like a pop star, and that's how this makes me feel. Does the witness's testimony agree with the other testimony and evidence in the case? It confirms. Yes, he was locked in the garage. She confirms the status of the room. She says that he had no other room in the house. She also says that the defendant is confined to that room for large portions of time in Florida and that he is punished differently than his sister for the same action. She tells us that she was allowed to go to the bathroom. She had a room. She had access. And so did her sister and even the baby. She tells us that at no point did she ever feel that there was any need for her to be protected from her brother, that she was never in fear for him, and that he never physically harmed her. There's one incident she can tell us about where he stole from her in Arizona. The defendant's actions towards the victim were normalized in the family. And I know that was really hard to hear because we did her through closed circuit. But as the judge told you, if it would help in your deliberations, you can re-listen to her testimony, and you can listen to the audio not from this courtroom, but from the courtroom we were actually in. But there, at the end, on that second day, we talked about, did it just, because this treatment was happening so often, did it become normal? And she said it was. And she said that at the time, I didn't have a name for what was happening to him, but I do now. And it was abuse. And then we have the testimony of Dr. Myers, who's an expert witness, a child psychiatrist who is still actively treating patients and a professor at Brown University. And he told us that based on his review, that the defendant's actions were malicious, cruel, and sadistic, that they constitute torture, that there was no legitimate justification for this ever, and the only reason that you do this is to harm someone. He told us that that treatment resulted in psychological harm. He told us that it was emotional deprivation, psychological deprivation, and a physical deprivation. And that leads to a psychological impact. In those cases, it leads to a child that is withdrawn, isolated, depressed. It can lead to suicidal ideation. It can cause existing behaviors to deteriorate. So if you take a child that maybe has some pre-existing trauma, that has behavioral issues, it absolutely under no circumstances will correct or treat any of them. It will only make it worse. He told us that it will stunt psychological and intellectual growth of a child. He told us, and we just had a lot of discussions about reactive attachment disorder and whether or not that is appropriate here. He told us that there are indications that there may be an attachment issue, but that the defendant's actions would increase and exacerbate any attachment issues. That this is the worst thing that you can do for a child for attachment issues. He also talked about post-traumatic stress disorder and told us that the defendant's treatment alone is a traumatic event that can be a precursor to post-traumatic stress disorder. And that's what he thinks is happening in this case, because he agrees that there is PTSD apparent here. He told us that even if they're not the original cause, they're not the chicken, they're not the egg, that it would make any symptoms worse. And there's been a lot of discussion about diagnoses and what it is and what caused it. I want to be clear. That does not matter what diagnosis there is or is appropriate or correct. It is not a legal defense. If a child has reactive attachment disorder, it doesn't mean you get to treat them however you want. What matters here is that there is an indication that the child may have been medically vulnerable because of past trauma, and instead of doing anything productive to assist that child, they did the worst possible thing you could do. Now, beyond the direct testimony, the photographs in this case, we have hours of Ring camera because the defendant recorded every single moment in that room. And like we said, it's not a continuous stream, it's 1-minute videos related to action. But we have hours of the treatment, of the confinement to prove, to corroborate what said, that he was in there alone.
You want to take this thing to the next level? Let's do it. Let's do it in Florida too. Let's do it in Florida too. Let's go.
word for it, that the treatment was extreme, that it was dehumanizing. We have the direct evidence of his actions. This is not a concerned father trying to make a reasonable correction to a behavioral issue. This is a man that is angry. This is a man that has actual malice, that has physical aggression and anger, because we see him put his hands on him, throw him on the bed, put his hands on his neck, scream on him, and then turn out the lights.
It's a man that has behavioral issues and should be locked in an 8x8 box.
And so his son is in an 8x8 box. The area that you're sitting in is bigger than that. Oh,
Sustain.
you can use your common sense for how big 8 feet is. Alone. And remember, we're looking through a camera that is has some night vision capabilities.
Overruled.
Told us what it's like to be in there, that when the lights are off, there is no ambient light. There is no window, that he's sitting in the pitch dark. So let's talk about the application of the evidence to the law. Aggravated child abuse. Malicious means wrongfully, intentionally, and without legal justification. What's in establishing or evaluating what is reasonable punishment? Is it corporal punishment? Things that are generally accepted as being a corporal punishment. A strike on the hand. Hitting a child on the back of their behind in a direct response as a punishment. Reasonable corporal punishment. Reasonable punishment does not subject a child to a risk of harm, and it does not cause actual harm, like the case here. It is not humiliating, dehumanizing, and cruel. It is proportional, and it is limited in duration. So let's talk about the duration here. Continuous. This is ongoing, and I think that's an important delineation here, right? This is not a proportional reaction to a behavior, like a discipline or a punishment. He has no other room in the house. There is no other place for him. Every other space is taken up. The parents have a room. Each of his daughters have a room. Has the office. So there is no situation where he conforms his behavior to whatever standards the defendant wants, and then he is out of the structure in the garage. This is his life, continuous, even in the best case scenario. But we know that it was more insidious than that, because we look at the duration. January 6th, he goes in at 8:10 p.m. That's when they lock up the door for the final time. No more bathroom, no more glasses of water, certainly no snacks. The door's not open until 7:10 in the morning. He's in there for 11 hours overnight. January 8th, he goes in at 9:39 p.m. January 9th, the door is not open again until 8:35 in the morning, 11 hours. January 9th, 8:36 to 7:39. January 10th, 8:36 p.m. until 8:25 a.m., 12 hours. No bathroom, not a drink, not a chance of getting a snack. No way to escape if there is an emergency or a fire. Locked, deadbolted inside. When we look at January 13th, 4:49 p.m. to 6:18 in the morning, 13 hours on a regular basis. And the exhibit that the state showed you, all of the ring videos are in from that entire time period, but then we showed you hours of videos that showed every event. So him going in, and then when they come in again, he gets out. So those are the major blocks, the major events. When they come in, they go in, they out. And those are the numbers that we're talking about. When we look at the total in a day, okay, fine, not just overnight. How much of a 24-hour day is he in the room? On January 10th, he goes to the bathroom between 7:39 and 7:45 a.m., or 7:43, so that's when he's let out. He leaves the room at 9:05. He told us he got left around 9 to go to school. And then he returns to the room at 4:59, so after school. And then he leaves the room to go to the bathroom at 5:56 to 6:18 p.m., and then he's in for the rest of the night. So the total, if we go 12 a.m. to 12 p.m., is 14 hours and 22 minutes of a 24-hour day, and he went to school. Huge portions of this child's life are alone in this room. On January 13th, same thing. He goes out for 2 minutes to go to the bathroom at 7 o'clock in the morning, almost 8. He leaves the room to go to school at 9 o'clock. Back in the room at 4:49. He gets dinner at 7:02 and lights off at 7:26. He's in there for 16 hours. We're going from 12 a.m. to 12 p.m. And he went to school. January 20th, same thing. 6:43 to 6:45. Leaves the room at 9. Back in at 4:45. This time without the lights on. Dinner at 7 p.m. Now, was this every single day? No, because as we look at January 23rd, he gets unlocked, he gets released from the cell his father made for him at 9:07 a.m., and he's not back until 7:10 a.m. So yeah, he's out for most of the day this one day. That doesn't change this, though. The psychological impact. And when we look at the proportionality, it's important to remember that the time frame that we are talking about is the crimes that occurred in Florida. And that is from December 2021 until January of 2022. You can see the things that he is getting in trouble for on that video. He's getting in trouble for stealing candy on that very first night. You stole chocolate from us, his mom says. Having an iPod in his room. Having a bad attitude. Lying. He tells a story about having a mock trial, and that wasn't true. Dr. Myers told us that kids subjected to this type of condition can have a fantasy life because they have nothing else going on, and so they have to have like a myth of themselves. Those are the things in Florida that he is being subjected to this type of treatment for. And I want to talk a little bit about intent, because there was a lot of discussion from the defense about intent. How do we determine someone's intent? For aggravated child abuse, it has to be that they maliciously punished, willfully tortured, or willfully caged. Those are intentional actions. We have to prove that the actions that they took were intentional, that he intentionally and purposely put him in that room, in that structure.
Objection, misstatement of the law.
Overruled.
That it wasn't an accident. That's the intention. That he willfully tortured, that he maliciously punished. Not every idea that was in his head. So how do we determine as a jury intent? We look to the evidence. You can make reasonable inferences from the evidence, and we look to his actions and then the things that he said in those circumstances. So let's look at the defendant's actions. That he did not give the victim a room in the house. He hired a contractor specifically to build this. He specified no windows, 8x8, lights controlled from the outside, lock, and a deadbolt from the outside. No bathroom, and he put that bucket in there. Each one of those steps are intentional, specific, deliberate acts. It's not an accident that this happened like this. We know exactly what he intended to do to his son. He set up the room. He put the camera in there. And then he forced the child to use a bucket. This is a screenshot from January 19th at 6:46 a.m., where he has to use the bucket. He had been in the room since 9:12 p.m. the night before. And this happened again and again. And in the morning, on one of the videos, you can hear the defendant tell him to take out the bucket and say, your neighbors don't need to see your piss bucket. From the outside, everything looked okay, but what was happening inside that room? Abuse. We see that the defendant's repeated actions to socially and physically isolate the child over and over and over again for hours last week. We watched him alone in his room eating. And Dr. Myers told you about the impact of that type of social and physical isolation. His actions to take away every little step and bit of autonomy that he had no control over the temperature even in the room.
Okay.
Did you turn the air on in your room?
Yes.
Are you supposed to touch that?
Did you hear Baba?
Yes.
Did you hear his question?
No.
are you supposed to touch air conditioning?
No.
Why did you touch it?
It was getting hot.
I don't give a shit if it's getting hot. You're a tough guy. You don't touch the air conditioning. I'll deal with you tomorrow on that.
You know, in opening statement, defense counsel said that there was just a design flaw in the room. It's not a flaw. These are intentional choices. This is what he wanted to happen. This is what the environment that he intentionally subjected his son to. An environment that no reasonable person would think was appropriate or acceptable. And then after they have that conversation, both parents come in and ransack the room again and leave him with even less stuff sitting in the room. We have the defendant's actions, his choice that not only would he substantially socially and physically isolate his son, but that they had to subject him to hours of sitting in the dark.
So that attitude? Yeah. Oh, you're so tough. You're gonna say yeah? You're gonna hold it out? Yeah, bad attitude. Tough guy. Tough guy. What's this here?
What we have here is anger and derision. We have
I wonder what he would have done if the kid would have said, "No, I'm better now. I'm sorry." Do you think he would have got all soft and been like, "Okay, good. Let's go hang out"? Or would he have kept yelling at him? Yeah, this is almost over, and we're going to go to the defense for those of you asking.
spite, and we want to cause him harm. That's why you're not trying to address behavior. What you're trying to do is maliciously punish him and make him sit in a dark cell for hours during the day. When we look at, oops, I have one more. This one. This is a few minutes later.
So that bad attitude? Yeah. Oh, you're so tough. You're gonna say yeah? You're gonna hold it out? Yeah, bad attitude. Tough guy. Tough guy. What's this here? Bad attitude? Yeah. All right.
So when we're talking about like the reasonableness of the punishment, like look what he's doing that for there. He has a bad attitude. His 14-year-old son has a bad attitude, and that's why he gets to be locked in a room with no lights, which to talk to Dr. Myers told us is the same as solitary confinement, something that is universally condemned for most humans, but certainly for children, because of the psychological harm that that type of treatment caused. And we can see about how often that type of thing is happening. The camera is installed in the room on January 5th. That's the very first video we watched. And we went through each of these. We see that on January 9th at 8:36 p.m. They're mad at him. He's in the dark. No ambient light. A 4x4 room. On January 10th at 6:18 to 7:06. Again, dark. On January 11th, 4:45 to 8 o'clock at night. And he doesn't get dinner that night because they're mad.
Ms. Coakley, pull the mic up because it's a recording issue for me.
Because they're mad. No dinner. On January 13th, again, 4:49 to 7:02, 2.5 hours in the dark in the middle of the day. And then they come in, and at 7:55 again for the rest of the night, pitch dark, no ambient light, not a window, 8x8. On January 14th, again, 4:49 to 7:02, he is sitting alone in the dark. Like Dr. Myers said, systemic, ongoing psychological torture of a child. January 15th, 5:04 to 7:32, 2.5 hours more in the dark. On January 19th, 7:45 p.m., those lights get switched off again. On January 20th, 4:45 to 5:51. January 24th at 7:08 p.m., he's in the dark. And then January 28th is the last day. It's the day that he runs away. The defendant made deliberate, intentional actions. He put his child, a child that he knew was vulnerable because of his early childhood experiences, into this circumstance. Every single night, for periods of time during the day, he locked the door over and over and over again and didn't allow him to even control the temperature. His only option was to use the bathroom in a bucket, and he had no access to water on multiple occasions. And then, in evaluating his intent about what he is trying to do in this circumstances, we have what he says.
Tell me something? Stand up. Tell me something? Don't tell me what. This is your one chance. Don't look at me like an asshole. You want to tell me something or not?
I have a nightmare.
Yeah, from where?
Blue van.
Where?
Green van.
Excuse me?
Green van.
Stealing again?
What the fuck is wrong with you?
You're stealing,
fucking
like,
disappointing.
chocolate, and there's you got so much stuff in your
You're
room.
fucking great. You're just such a disappointment. You're gonna lose. I'm gonna take you out of that school. And you're gonna be in this room.
He's gonna be.
You're this close.
Where are these in here? Who got these? This like belongs to the kids, or
Let's get some very soon. See what your lion does? See what your lion does? You see it?
is this?
We're going back to this?
Is this tape in?
So what we have is anger and derision. That's what's governing his decisions. And that's why we know that it's an intentional act.
Stand up. Why are you giving people shit attitude? Fuck that! Don't say I don't know. Why are you giving a shit attitude?
I'm not thinking.
Fuck that! Why are you giving a shit attitude? Answer me! Before I get really fucking pissed off, answer me. Why are you giving her a shit attitude? We're in school today talking to your people to give you a better opportunity. You got a fucking shit attitude?
And after this, when he exits the room, he again turns off the light and leaves him locked in the room. And so how does that impact our ability to determine or make a conclusion about what his intent is? This isn't about getting a productive response or even having a proportional type of conversation. This exchange is about him having a bad attitude. And you can see, even here, we're trying to say, I'm not thinking. That's why I'm having a bad attitude. And there is anger, aggression, physical, the specter of physical force, as opposed to having any kind of conversation with the child. And then the response is to not have a conversation with them, not try to do anything that would be useful. Instead, locks him in the dark in an empty cell and puts him, turns the lights off because he's mad. He has malice towards the child. Now, I want to talk for a second about Arizona, because I know that maybe it can be a little bit confusing. We've had a lot of conversation about things that happened in Arizona and what happened in Florida. The defendant is charged with the conduct that occurred in Florida. And the judge has given you an instruction about how to weigh that conduct and how that can impact your deliberations. And that instruction is that the evidence of those other crimes, wrongs, or acts can be considered for the purpose of proving motive, opportunity, intent, preparation, plan, knowledge, identity, or the absence or mistake of accident. So that means that when considering the defendant's intent here, you can take into consideration his actions in Florida. You can take into consideration that this is not just something that he suddenly came to in Florida, that it just happened for 30 days. You can take into consideration that this is something that the defendant had been subjecting his son for a period of 3 years. With, as Dr. Rapper told you, really no improvement, right? Like he was still having the issues that the defendant was concerned about, the bad attitude, stealing the sprinkles. And so, despite the fact that it was not helpful, that it was harmful, he continued to do it. It's an intentional act. That he continued to lock his structure, his child in that structure, that there was a bucket, that there was no control over the lights or temperatures, that he used physical and social isolation. That this is not just something, oh, let me give it a try. This is something that he had been subjecting his child to for years. And you can take that into consideration when determining his intent here. That this was his plan, that he wanted to do this, that it was not a mistake. You can also take into consideration the physical abuse that happened in Arizona in evaluating the evidence in this case about what he was doing and what he was intending to do. I told you that there were instances where she could hear the victim screaming while he's being struck in the garage in Arizona. She told you that there was one incident where he grabbed the child by the neck and lifted his feet off the ground and was worried that he might accidentally kill her brother. And it told you about those incidents too. And the reason, although he's not charged for those incidents here, the reason they matter here in your evaluation of the evidence is because that threat of violence, the fact that the defendant's anger and aggression and grabbing him by the neck like he does in the video, of shuffling his arm, of getting up in his face, is not posturing. That threat of violence is very real and significant for. And you can see that in the videos. You can see him cower. You can see him stand almost withdrawn. But it influences what the defendant is trying to impose on him with those threats, and also his understanding of what can happen if he disobeys. So let's talk for a second about the defense case. They put on some witnesses, and for the most part, the first day witnesses were the defendant's friends, with the exception of the teacher. Those friends do not know and never were in Florida.
That's why I trim it up
They
for
do
you.
not know what was happening when the defendant was alone in a home with his son, and they do not know the type of punishment that he was subjected to. And absolutely none of them have any firsthand knowledge of what happened in Florida, because they never came in Florida, they never saw anything, and they do not know. The defense also put on a number of videos that we spent the better part of yesterday afternoon watching, which are times where it was outside the house. And what we see from those videos that we saw yesterday is that for the vast majority of the time in the recording, that the victim is able to conduct himself in a family environment. He plays nicely with his little brother, who seems to very much love him and want to play with him and is following him around and trying to get him to interact. He is able to behave appropriately with his other siblings. You see him playing with the dog. We do not see violence or aggression. You know, there's been kind of this idea floated that we had to keep the family safe. There is no evidence of that. The evidence is to the contrary. The person that was jeopardizing the safety of the Ferriter family was Tim Ferriter. We see that there are periods that he wasn't confined. And we agree with that. I told you about that. When we look at the videos, we saw some videos of him on a scooter, which is on January 7th, 2022, after school. You can see in the videos that the state published that that's the outfit that he puts on. He leaves for school, comes back, he plays on the scooter. And then at 5:42 p.m., he's locked in the cell. And he eats dinner in there alone. And he's in there until he goes to sleep in the room where he cannot leave to get a glass of water or to get a bathroom. On January 9th, this is a Sunday, 8:45 a.m., the state's evidence is he's let out from the room. Then, like he told you, he was often, when he was outside of the room, having to do yard work. We see him in the defense exhibit moving those mulch. And you see in the defense exhibit, I took a close screenshot, but if you look over, the defendant and his wife are sitting at the table while the child's working. And then later that same day, there's those videos. Like he told you, one of the things that he had to do was to clean up all the rocks. And the state put into evidence video after video of him out there by himself, by hand, taking up the shelves. You see the defendant come take a look and come back and say, every single rock. So yes, he did get out of the house, and sometimes he got to go on a scooter. Sometimes he had to do yard work, but at 6:25 every single night or earlier, he's locked in that room. The fact that on one day he watched a football game with his dad does not vitiate all the other days of systemic abuse. And then we have the testimony of Dr. Rappa. Dr. Rappa is their expert, a psychologist, and she told you that the way they chose to manage was probably the worst way that any person could manage these types of behaviors. She told you that the defendant's actions are the complete opposite of what anyone should have done with a child that has one of these conditions. She told you that there is a likelihood of psychological harm even in children that had no underlying behavioral issues, that this is going to be harmful to anyone, but especially someone like me. She talked about PTSD and reactive attachment disorder, and she told you that the defendant's actions would exacerbate the symptoms, that what he did made it worse. Actual harm. That is the defendant's own evidence. She says that this is not the recommendation that they received from any treatment provider. That she went through the records, and that what was recommended was medicine and therapy. And that there was very little of that done. And the last time that they dealt with any mental health professional for their son, who, according to the defense, they're so concerned about his behavior, was in 2019. The time frame that we are talking about is December of 2021 to January of 2022, 2 years later. No efforts. And we can see, and it's in evidence, you can take a look, when he is enrolled in school at the Palm Beach County School District at Independence Middle School in January of 2022, you fill out enrollment paperwork. And there, Tracy Ferriter says, normal dental, normal skin, normal eyes. Any concerns about general health? No. Any other specific illnesses or social or emotional or behavior problems? No. At no point did they try to get an IEP, an individual educational plan. At no point after 2019.
Objection, facts not in evidence as to the IEP.
Overruled.
We heard that, there was one email sent to someone about transcendental meditation, 2022. You know what else happened in 2019? Instead of doing anything productive to deal with the trauma maybe experienced by their sons or their behavioral issues, they locked him in the garage. Their biological son was born, they needed the bedroom, and went into the garage. 2019 is when they stopped with the mental health professionals, and 2019 when that is happening. Those actions, what the defendant is taking, is not reasonable punishment meant to correct something. It is malice, it is willful torture, it is intentional caging of a child. Now, Dr. Rappa, there was a discussion about what started the PTSD. Was it the defendant's abusive actions, or was it just his childhood neglect? And you got an instruction about how you can evaluate a witness's testimony. That instruction is that you get to use your common sense in deciding what is the best evidence. You get to decide what should be relied upon in considering your verdict. You may find some of the evidence reliable and some not. So you can say that some of what Dr. Arapa said makes sense to me and I think is appropriate in light of the totality of the circumstances, and some of it doesn't really line up.
Real quick, I just want to say a big fat happy birthday to Miss Big Tiff. Love you.
But our experts agree, unequivocally, the defendant's actions were harmful. They should never have occurred, and they would have led to worse behavior for the victim. That there was absolutely no benefit to what they did. Instead, they were harmful. In a criminal case, the state's burden is proof beyond a reasonable doubt. And the law instructs us on what a reasonable doubt is. A reasonable doubt is not a mere possible doubt, a speculative or imaginary doubt. Such a doubt must not influence you to return a verdict of not guilty. And so what does that mean? If you're back there in the jury room and you find yourself speculating, well, this is what they could have meant. And it's not based on evidence, it's speculation. The law is that you have to stop. If you find yourself forcing a doubt or imagining a doubt, the law is you have to stop. A verdict of not guilty can only be based on a doubt that is reasonable. And when we look at the totality of the evidence in this case, there are no reasonable doubts left. Now, one of the instructions that Judge Coach just gave you is what the lawyers say is not evidence, and you should not consider it as such. The exhibits, the testimony, the video recordings, that is evidence. What I say and what the defense says is not evidence. You get to use your common sense. Every single day in courtrooms around the country, we convene ordinary people, and we ask them to use their common sense about what is reasonable and about what is appropriate and what evidence is proof beyond a reasonable doubt. For about 6 weeks, he was locked in a room in Jupiter, Florida. And yeah, he got to go to school, and sometimes he got to go on a scooter, and sometimes he got to play with the dog. But as you heard from Dr. Meyer, that doesn't change the impact of this type of treatment has on any child, but absolutely on a child like the defendant's intentional, repeated acts caused harm. Any person would know, any reasonable parent would know that this is not acceptable. Any reasonable parent or person would know that this is going to harm. And despite that, over and over and over again, Tim Ferriter made that intentional, deliberate decision to treat his son like this. That's actual malice. That's intentional torture. That is willful caging. It's aggravated child abuse. It's child neglect, and it's certainly false imprisonment. It's not just one thing or one moment. It is all the things over and over and over again. What the defendant did was a crime, and that's why we're here today. Like I told you, it was dehumanizing, and it was traumatic, and it should never have been done. Based on all of the evidence, that is why we are asking you, all of that evidence, those hours of tedious videos, and I know it was tedious to watch them, but the reason that we did is to see just a moment of what that tedious life was like for here. Based on all of the evidence and based on the laws of the state of Florida, we're asking you for the only verdict that is supported by the evidence and supported by the law. And that is a verdict of guilty. Thank you.
All right, everyone may be seated. Ms. Murad, is the defense ready to make its closing? Yes, sir. All right, you may proceed.
I just want to say good morning to everybody who I didn't say good morning to. I am watching the Law and Crime stream on another channel, and if anything happens, I will switch over to that.
There is not one moment that I want you to think that this defense is about whether or not deserved the treatment that he got, because it is not. Or that the fact that he is vulnerable or had medical issues from early childhood is justification for what happened, because it is not. However, we are in a criminal courtroom, and what you have to determine is whether an act, a horrible act of parenting, a bad act of parenting, bad choices amount to a crime. And in this case, they do not. I told you at the beginning of this trial that Tim Ferriter had to make tough choices based on the experience that he had had with his son. And I'll talk about that more in detail. But what I want to start with is sort of the bedrock of any criminal case, which is an understanding of what reasonable doubt is. There is an instruction that you will receive, and we'll talk about that later on in my closing argument.
Approach. All right, objections overruled. You may proceed. And that's without prejudice to the state to address it in rebuttal.
So there's different ways to understand reasonable doubt. And I think that a helpful way to understand it is in terms of sort of the other standards that we have. So at the bottom here, you see reasonable suspicion. And that is like a super low standard. That's why it's on the bottom. So that is the standard that a police officer has to have just to sort of stop you on the street.
Sustained.
When we talk about reasonable doubt, it is in reference, right, to all the other standards, because beyond a reasonable doubt is the highest burden in our justice system. Normally, when we talk about a criminal case, it's different than, for example, a civil case, where you are deciding whether or not something is done by the preponderance of the evidence. That's about 51%. The next level up from that is clear and convincing evidence. And that's the standard required for the government to take your children away.
All right, I'm going to instruct the jury that the court will provide and has provided you with the instruction on what reasonable doubt is. Attorneys can comment on the law that the court has provided, but anything else other than what the court has provided on the law, the attorneys cannot address, and you're to disregard that. So with that instruction, Ms. Murad, you may continue.
Thank you, Your Honor. Clear and convincing evidence is the standard by which the government
Overruled.
can take your children away from you. And then higher than that, you have beyond a reasonable doubt, which is the highest burden in our justice system. And this distinction is important because when we talk about bad parenting or someone that shouldn't have their kids, there's a standard for that in the legal system. There's a system in place for that. What you are being asked to do is determine if something is a crime, if it rises to the level of reasonable doubt, such that a person whose liberty and freedom is at stake, as it is in any criminal case, should be found guilty of a crime. You are not being asked whether you condone of Tim Ferriter's actions. I put up an expert, Sheila Rappa, who says she does not condone of Tim Ferriter's actions. And I didn't do that not knowing what she was going to say. This case is about a different sort of location and time than what the state's talking about. There is no dispute that what Tim Ferriter did caused harm to. My own expert got up and told you that. The question before you is whether or not that was done with the appropriate intent to be considered a crime, whether or not those elements that the state mentioned are met. And so I want to talk about those in specific. Let's start with this. What are we actually on trial here for? The state mentioned a instruction towards the end of their closing argument regarding the things that happen in Arizona. And of course, the defense brought some of that in. It offers context. But the decision that you are making is whether or not Tim Ferriter committed a crime during about the 6-week period that he lived in Jupiter, Florida, between January 5th to January 28th. That's when the video goes up in the room. They move in a little bit before Christmas. That is what you are being asked to do. If you believe that Tim Ferriter committed a crime in Arizona based on the testimony, but you do not believe that the state has proven beyond a reasonable doubt that he did so in Florida, you must find him not guilty. I don't normally do this, but this is a lengthy closing, so I want to make sure that we talk about all the different sort of reasons why Tim is not guilty. I'm going to talk about these all in turn. They apply to different instructions. So rather than taking you through instruction to instruction, I want to focus on the reason for it being not guilty and the instruction that it applies to. So we'll go through these one by one. I first want to start by talking about sort of two ways that you can find Tim not guilty that are pretty related. First, he did not have criminal intent. This applies to every charge, right? Because criminal intent is something that is unique to a crime, as opposed to something in a civil case like negligent intent or something along those lines. Even if you find that the state has proven every element, including that criminal intent element, as to child abuse and aggravated child abuse, you can still find him not guilty because of the parental affirmative defense. Now, the way that that reads is that it is not a crime for a parent of a child to impose reasonable physical discipline on a child for misbehavior under the circumstances, even though physical injury resulted from it. And this is the important part. If you find that the state proved beyond a reasonable doubt that the defendant was not a parent, that's not an issue here, or if you find that the state proved beyond a reasonable doubt that the defendant's physical discipline was not reasonable under the circumstances, you should find him guilty if all the elements of the charge have been proven beyond a reasonable doubt. This is a little hard to understand, but this is a two-step process. First, the state has to prove every element of that aggravated child abuse or child abuse beyond a reasonable doubt. And then the second bit is they have to disprove this affirmative defense beyond a reasonable doubt. It is not the burden of the defense to prove to you that it was reasonable. It is the burden of the state to disprove to you that it was not. This trial is not about diagnosis, but I understand that it's been something that we've talked about a great deal throughout the course of this case. It is, however, essential to understanding the sort of persistent behavior that Tim Ferriter experienced. And it allows you to understand how difficult it was for Tim Ferriter with sort of ongoing behaviors. And I want to start with sort of the thing that's based most in science, which is Dr. Rappa talking about a neuropsychological exam. So that neuropsychological exam, as Dr. Rappa testified to, has multiple parts. And this is testing that the psychological and psychiatric community relies on routinely. And it allows us to have data about a person to explain how they are the way they are and why they are the way they are. This neuropsychological testing has multiple parts, and it includes something from himself and from an adult parent. Dr. Rappa explained that. And in this particular testing, there was no reason to believe that there were any sort of validity issues with the information that she received. She also said that even though the testing was from just a couple months after January 28th, that doesn't matter because it still is a test of executive functioning. What that testing revealed is that it has clinically elevated levels as it relates to inhibition and emotional regulation. And what Dr. Rappa told us is that that means, it explains this sort of persistent behavior that's not stopping, that becomes explosive. When one has when one feels angry or has sort of a strong emotional reaction, he's not able to control that in the way another person might be. He also has a lack of inhibition. And that's why when he has consequences, that's not something that he's entirely understanding. She said that it's very hard for someone who tested like and did to be in control of themselves, and they have a lack of insight into their own behaviors. She also explained that this testing, right, goes back to early childhood, and that's not really in dispute. The state's own expert, Dr. Wade Meyer, said that he believes he has probably an attachment type of disorder from the time that he lived in an orphanage. Again, there's no dispute that the Ferriter's actions exacerbated that, right? Dr. Rappa told us that. That's something that the defense is completely conceding. But both Wade Myers and Dr. Rappa say that this is something the Ferriters did not cause. It is from very early childhood neglect. And what we see and what the key is, and Dr. Rappa talked about this, Wade Myers had to concede to it, there are behaviors before 2018, right? That's when we're talking about the timeline, we know that this was born on February 28th of 2019. About a week prior to that, per his own testimony, a room was built in the garage in Arizona. Before that, while Tracy was pregnant with, a latch was put on his door in Arizona. So that has to be late 2018, early 2019. Prior to that time, Dr. Rappa testified about records that she reviewed from 2015, elementary school emails about ongoing and persistent behavior. And I asked her, because look, I understand, and the state made light of it, but stealing sprinkles or activities that are just considered childhood behaviors. It's very hard to distinguish what constitutes regular childhood behavior and what constitutes a disorder. And I asked Dr. Rappa that during her direct examination. And what she said is that it is the persistence of these behaviors, that despite there being consequences, despite there being boundaries, they continue and continue and continue. In cross-examination, Ryan admitted in great deal to his own behaviors, right? He admitted to harming other people. He admitted to offering his brother beer as an experiment. Sev de Borzati testified that a time that they were visiting an Airbnb in Sedona and was found with knives in his backpack. And the cross-examination on that was, well, did he threaten you with a knife? Did he use a knife? An 11-year-old shouldn't have knives in their backpack. Right? That's everyone's common sense. That as a young child, there are certain things, certain boundaries that you cannot cross because you're a kid. And admitted to stealing from his own home, stealing from the parents of some of his friends. He admits to running away. He admitted to breaking into his tablet at his last school in Arizona and searching violent terms that concerned his parents. And that was the reason why he had to get his technology taken away. Kellen McCoy, who was a teacher of Lynn's, testified about an incident that he had with his sister. And in cross-examination, the state was asking Dr. Rappa about these sort of specific incidents, trying to minimize them or showing that, any one act is no big deal. And that's with any kid, right? Any one act that a child does out of being a kid or immaturity is never a big deal. But it's when it continues and doesn't stop over and over and over again, and when it escalates, and when it becomes persistent, and when in this case you have a neuropsychological exam that supports that it becomes a disorder and something that is problematic to the child, to the parents, and to everybody that he's around. So Kellen McCoy testified about an incident where he entered his sister's classroom, had her stand up, and humiliated her in front of the entire class. And during cross-examination, I recall Ms. Coakley saying something to Dr. Rappa, and Dr. Rappa was like, no, but it seems small, but that's not the case. And Ms. Coakley interrupted her at that time. But you have to think about the steps it takes, right? To decide to go to an entirely different part of the school. That's what I'm testified to. Pretend to be another person. Decide to point out your sister. Go to that classroom. Have the courage to come up with this entire story. That is something that gets to the level of being manipulative. And those are the concerns that were happening throughout his life. And that's corroborated per Dr. Rappa prior to 2018. Through records that she reviewed, through his own deposition that she reviewed, through, I think she listed off 25 items or 26 items that she reviewed in coming to her opinion. Dr. Rappa also testified how when you have a lack of trust in a parent-child relationship, and I guess you can rely on your common sense for this, but when you have a kid, right, and they're growing up, you rely on trust. But we rely on that in any relationship that we have, that what we see is what we get, right? That what we expect when someone says, I'm going to do this or I'm not going to do this, that they actually follow through with that. And that relationship of trust is really important between a parent and a child. And when it is broken, Dr. Rappa said that the response that a parent has, the natural response, is to control, right? And we see that in our everyday lives. If you have a kid who's out, joyriding, you don't get the car, right? If you are someone who is fighting at school, you're going to be in a timeout. You see in this case that it is taken to an extreme. But it is also in response to an extreme. Because that kid joyriding who doesn't get their car stops. Most people's children stop when they say, you can't do this anymore. I'm going to take away your items. I'm going to put you in a timeout for a reasonable amount of time. I'm going to ask that you stop doing it. I'm going to ask that you not, hurt people at school. I keep getting emails from school about how your violence is becoming a problem. I need you to stop doing that. Eventually, kids stop. But it didn't. It persisted over and over and over again for years. I want to show you a video of how Tim Ferriter responded to Run.
To the next step. So if you don't give a shit, and you want to run away, see how that takes you. I'm not chasing you this time. See how it goes. If you want, should I put this ankle thing back on you? Because I kind of need to know where you're at, just so you don't, hurt yourself. Because you have no fucking idea what's out there. You think you do. All 14-year-olds, 15-year-olds, these kids you're around, you might think you know what's going on in the world, but you don't quite know. Give it a try. Go ahead. And I gotta put the ankle bracelet on you. Because I'm responsible, and when I say I'm not giving up, I'm not quitting, you got me forever. So deal with that. But if you want to go throw your shit away, if you want to ruin your life, if you want to destroy this shit, I'm not going through this again and again and again. I don't have time for this shit. I got to deal with to the next step.
You can hear Tim Ferriter, as Rappa said, in the worst tone ever sometimes, attempting to parent, right? And it is not perfect. I don't think any parents, would say that their parenting is perfect or even great in retrospect. But what he's telling him is, if you keep running away, I'm going to have to put a monitor on you. And of course, that sounds like an extreme thing to do. But what he tells him is, you're 14 years old. You don't know what's out there in the world. I have to keep you safe. Because if you keep running away on the street in the middle of the night or during the day, you're going to get hurt. Someone is going to harm you. And I am your parent, and I have to keep you safe. And it got to the point where they're talking about putting a monitor on him. That's how often this was happening. And no parent can allow their child to run on the street, right? No parent can allow their child to be lost and not go find them. So he's telling him, you have to stop. He's telling him there is a big world out there and you don't know about it. And I know you think you do, kid, because you're smart, right? You're able to trick people. You're able to convince them that your name's Richard, I think came out in a video. But it is a big world out there. And there are people that could harm you. Tim Ferriter was trying to raise a child who could make it when he's older, without having a criminal record, without having a million issues at school, graduating without getting kicked out, because we saw in the videos that he got kicked out of his last school in Arizona, and with positive social skills. If you are hiding knives and pretending to be people that you are not, and stealing money from your friends' parents, and bringing a scalpel to school, and getting into fights so often that your elementary school is sending emails in the 4th grade. When you are 6, 7, 8, 9, and 10, what are you going to be doing when you are 20 years old? And another point I want to make is this idea, when we talk about malice and intent, that this was something that Tim and Tracy Ferriter enjoyed, right? The benefit of your kids growing up, right? I have a bunch of friends with toddlers. They're just hyper vigilant all the time. They have to watch every minute of what that kid does because they're going to get hurt. They're going to put their hands in the socket. They're going to, right? That's that life. And as a parent gets older, that goes away a little bit. You can go out to dinner. You can grab a cup of coffee on a Sunday morning. Tracy Ferriter is watching his laptop, and for a reason, because he has broken into numerous school laptops and hacked into his entire school's IT system. And she says, I need you to do your homework so that I can see it on the camera. This is not fun for them. Waking up in the middle of the night to see if your kid stole an iPad from his sister is not enjoyable for a parent. Staying up in the middle of the night to make sure that your kid isn't doing something they're not supposed to do, keeping that kind of hypervigilance year after year after year for almost a decade, is not something that a parent wishes to do. But they had to keep this type of monitoring on. And they did. And they did it without getting him arrested. They did it without sending him away. They did it without ending the adoption. There was always a reason, if you go through the videos, and there's a lot of them. I know you watched many of them. If you watch all the videos from inside that room, and I know we watched about 8 hours of it together, you can hear Tim telling every single time he's in trouble. You did the Chromebook again, right? You can't break into the Chromebook. There was a time, and admitted to it on cross-examination, where he went into the school, he went into a different teacher's classroom and said that he was evaluating the teacher with the school board. You can hear Tim say that. This idea that it is gratuitous It even says discipline to you was always in response to something that you did. And then said yes, whether that was a timeout, whether that was getting yelled at, whether that was getting in trouble, it was always in response to something. And I'll concede what Dr. Rappa said, that the tone was not appropriate and the strategy was not appropriate. That is not in dispute here. But to say that it wasn't reasonable to Tim Ferriter, who had a reason every time it was happening, that is inaccurate. When he talks about the AC, admitted in his cross-examination, it was right at the end of my cross-examination, I asked him about when he almost started an electrical fire at the home in Arizona, right? And he talked about how he was playing with the lights and tried to mess with the light switch. And he initially said, it wasn't going to be a fire because I would know how to fix that. And I said, that could really hurt somebody. And he said, yeah. So he's not allowed to touch electrical items or, equipment in his room. You can hear when Tim is talking about specifics. We talked about that. So I want to talk now about what you experienced during this trial versus what the Ferriters experienced over the course of time. So this trial, right, is really talking about not just what went through, but also a parenting relationship. Anytime something's happening to a kid by a parent, there's a relationship there, right? A parenting relationship that spans time. And what you saw was over about a week and a half. I know it feels like forever, but it was about a week and a half. And when you saw him testify, it was about 2 hours. That is not what you are seeing in those videos that the state played. What you are seeing in the videos the state played is after year 1, 2, 3, 4, 5, 6, 7, 8, 9, 10, 11, 12, 13, and 14 of ongoing issues. And you are
Sustained.
And you are
Jury's instructed to disregard the last comments of counsel.
And what you are seeing is a family at their wit's end. There's no doubt about that. And I don't know a single parent, take away a child, take away all the variables, a child with behavioral issues or a diagnosis or even just, sort of benign behavioral issues. A parent and a 14-year-old or a 13-year-old, a preteen. I don't know a single parent who would want their worst couple months, their worst year with their relationship with their kid filmed on camera for everyone to see, without any context, without any understanding of what was going on the years prior, without any understanding of who they are.
Sustained. Jury is instructed to disregard counsel's comment on her belief on the evidence.
We talked about whether or not this was in fact malicious punishment. And both Wade Myers and Dr. Rappa testified about that. And they testified in a different manner. Here's what I want to remind you about Wade Myers. The information that Wade Myers had was curated by the state and provided to him in the same way that we provided information to Dr. Rappa. But what he said is that he received 40 videos of the 21,000 that exist in evidence. He received 40 videos of the 8 hours that you watched of the state's evidence and the 3 hours that you watched of the 14-hour video that the defense put in evidence. That is not an entire picture of what happened in this family. In fact, if I remember correctly, when my colleague on cross-examination said, "Are you aware that there are 21,000 videos in this case?" Wade Myers' face visibly was like, "Oh, I didn't know that." So his opinions are based on a limited set of information, acknowledging that he may not have the entire picture of what was going on in this family. Dr. Rappa testified that she didn't believe that this was malicious. and you can evaluate the credibility of any expert the way that you want. Dr. Rappa, compared to Wade Myers, testified on cross-examination in a manner that was very honest and not in any way
Sustained.
And not-
It'll be up to the jury to determine credibility.
she didn't fight with the state in the way that Wade Myers did, the way that Wade Myers did with the defense. And she admitted to everything as it relates to the harm caused, the fact that this is an inappropriate way to handle a child. That is something that Dr. Rappa said was absolutely true, right? So when she's looking at all this information, she's telling you that the reason it's not malicious is because this was a poor effort at parenting a child that has issues that these parents did not understand and that providers did not give them. She said that it's common in mental health types of situations for families, parents, to get really, really frustrated because they are runs on clonidine. That's not working. This isn't working for sleep. They're getting advice about limit setting. That's not working. They're getting advice about take him to therapy sometimes. The one-on-one therapy that he had with family counseling wasn't working. It's not changing the behavior in the school. And that's happening year after year after year. And Dr. Rappa said that it's really common in her field, and she's worked with a lot of children who have similar issues and a lot of parents in these types of situations as well. And it's very normal to feel extremely frustrated with the mental health system, right? Because you keep doing stuff, you keep taking them to the appointments, and nothing is helping. And not one of these doctors recommended inpatient treatment. Not one of these doctors recommended what Dr. Rappa said would be appropriate treatments for reactive attachment disorder. So they're following the advice that they are receiving, and nothing is helping. When I was talking to in cross-examination, he had to be reminded of this. But he said that he was going in Arizona to appointments about once a week. So many that he didn't remember who the providers were. So this idea that they didn't try is not true. He himself has said that he was going and seeing people once a week. Both experts testified that there were emails between the schools and the parents talking about Rin's behavior, trying to figure out how to deal with it. Ms. McCoy, the former teacher, testified that after the incident with in the classroom, Tim came with Rin separately and Tracy went with in order to try and talk to the teacher and figure out what was going on. The idea that these parents were not involved and not trying is distant from the facts. There were also non-medical efforts, and I know that it sounds silly, the meditation, but this is a family that from when this child was a kid was like, okay, what are the non-medical options that we can try? What can we do to burn off his energy? What if we don't give him sugar? Maybe that'll help. What if we don't, put him in karate, jujitsu, put him in these activities like track, what he did in Arizona. He did chess club. In one of the videos, you can hear Tim say, didn't get it because he stole an iPod or an iTouch, but he said, I was going to get you that gaming computer that you really like because this kid is really good at IT, at gaming, at that kind of stuff. So they're trying to get him into activities that they think will help his behavior because none of the medical interventions were doing it. The state mentioned in their closing argument that after 2019, there was no evidence of any medical treatment. That's not true. When the state was asking Dr. Rappa the same thing, she said, I think there were some appointments with Kenny Miller, and when they started school in Florida right before Christmas of 2021, there's a record that shows that they went to a pediatrician like you're supposed to go to, and that they asked for a referral for a psychiatrist, right? And you can use your common sense here. That's not something that happens overnight in any doctor type of situation. You have to get a referral for psychiatric care. I want to go now to points 3 and 4 that I had in that sort of initial slide or roadmap. So I want to talk about with you sort of life at home. And this goes to the elements that this was not torture, which goes to the aggravated child abuse, and that it was not malicious punishment, which also applies to the aggravated child abuse. Where women lived, whether it is appealing or not, is a room. And I want to show you, this is Defense Exhibit 2. When Ben moved into his room, this is what it looked like. And you can see the girls' rooms. The photos aren't great, but this is not in size that different from what the girls' rooms are. It's an 8x8, which is about the size of a small room. He has his toys, he has his Legos, he has everything on the walls. This is how the room started. The room itself for women was not punishment.
Let me hear from everyone. May be seated. All right, I'm advised that the jury has apparently had a piece of evidence reviewed that was not in evidence. I don't know how that happens, but it apparently was the arrest of the defendant. So let me hear from, excuse me, of the victim. So how did this happen?
I don't know, but they put in that, they're on a rule that they can just put in a picture of him or like a showing what he looks like. And on the USB that they put into evidence is 2 files, one of which is labeled as Roland's arrest. And then the other one also says he's going to be arrested, and they said that they published it out anyway.
Can you guys hear
There's
it?
been no publishing of an exhibit where he was arrested, the victim?
What happened was we had a video when he was originally in school. We went sidebar. The court said we could play a trimmed version of it that just shows what he looked like at the time on that day.
That's right.
Why is it such a bitch to get this to work? Share screen. Share audio. This. Share. Now can you hear? Oh,
The longer version
now can you
wasn't
hear?
deleted out. So there was 2 files on there instead of just the one that says trimmed.
So how does that happen, Mr. Waheed? Isn't that on the defense? That was your exhibit. You were required and responsible for making sure that what was admitted in evidence and what was published was to be on that thumb drive. And now I'm hearing that they have seen something that was not admitted into evidence?
That is all correct, and it is our responsibility. I'll take responsibility for that. That was the day. That was the first day. It was a very, very busy day. As we moved through the day, it was completely inadvertent. I think I did the crosses for everybody that day. So I didn't really look at that evidence at the end of the day when we were trying to get it to Madam Clerk. So that was a mistake.
All right, Ms. Coakley, what's the state's, I'm,
I think it needs to be an instruction to the jury to disregard it, and it also is factually inaccurate what they had it characterized as. He wasn't arrested, he was just detained and never arrested. So to indicate that he was, like, there was just police procedure that he was detained for a moment when it cuffs. There was no arrest here. So to indicate that he committed some type of crime for which he's arrested now, based on how they labeled this, which they provided to the jury, is really problematic. And, you know, they had to play it without any sound. I had to play a video without any sound, because unfortunately, I advised him that we didn't send that back.
Well, to say that I'm displeased with this development would be a massive understatement. This trial is, we're in the 9th day. I rely on the attorneys to make sure that the evidence they submit, and based on my rulings, properly reflects what my rulings are, and that the jury sees only what has been admitted into evidence. Let me hear your position, Mr. Waheed, on the state's request for limiting instruction. I assume it's going to be something to the effect that, well, one, the exhibit's got to be corrected. The proper file has to be put on the thumb drive. Secondly, it would be an instruction that, to the extent that they have seen documents or videos that were not received properly into evidence, they're to disregard that. And also, your concern is about the nomenclature of the file name, right?
Like a factual stipulation that he was not arrested, it was just police procedure for a runaway.
Okay. Your response, Mr. Waheed?
Just to be clear, the right evidence is on the thumb drive. It's just that the untrimmed version was still left on it. So I just wanted
Well, how can you say that? If you say the right evidence is on the thumb drive, and now I'm dealing with a situation where the jury's reviewed something that they were not supposed to have reviewed, which was not in evidence, those two things don't mesh with me. I mean, either the pared down video is on it, or an improper video that includes something more is on, right?
they're both on it. That's my point. That's all I'm trying to just say. So I agree with the state that the longer version needs to be deleted. I also agree with the state that my recollection is the court's ruling was to play it without audio. So it would be something that doesn't go back to the jury, that they would have to play out here without audio, just like one of the
We're
state
3
exhibits.
minutes behind
I
live.
also agree on a limiting instruction.
Okay. All right. So, Mark, I want you to retrieve the thumb drive that they were reviewing.
It has.
Oh, you already have it?
Yeah, and the state's also asking for a factual stipulation, because it's great, what's on there, what they've seen is him getting handcuffs and led to a police car. And so, and it's labeled as Roman's arrest, which is factually false. He was detained because he ran away.
Well, I thought that I heard Mr. Waheed not object to my limiting instruction where I would advise the jury that the victim was not arrested. He was just simply detained as part of the normal practice in dealing with runaways.
That's correct.
All right. You can go ahead and bring them out.
Give me a moment, Judge. We're just going to fix this.
Okay. Well, that doesn't need to wait. You can do that and not take up the time of the jury on that.
Here.
And we are waiting for the queuing up of the replay of Fiona Ferriter's testimony. Okay. All right, you may bring them out.
So what happened was the pretrial right before opening statements, the defense was arguing that they wanted to show this video,
Right,
and it
everyone may be
included the
seated.
child being
All right,
arrested. And the purpose of it was to show the child's condition right after he was found after being after running away. And the prosecution argued there's tons of pictures of him like that you could show instead of this video of him in handcuffs. That's prejudicial to the jury. And the judge agreed that's completely prejudicial. Absolutely not. You cannot show this video of him in handcuffs. If you want to show a portion of it where he's not in handcuffs, if you want to show these other pictures, that's fine. Do not show that video. So it should not have been in evidence. And the defense went ahead and did not and submitted it to evidence anyways.
Members of the jury, first order of business is that I did receive your request for the replay of the testimony of Fiona Ferriter that is being queued up. It takes a while
I hope
for our
not.
recording to get it queued up for proper replay to you. And so that's in the process. I don't expect it to be too much longer before that'll be queued up.
Defense.
The other thing is I'm advised that there was a video that was sent back to the jury room that was on one of the thumb drives that apparently was erroneously included on the thumb drive and should not have been something that the jury would have been permitted to view. So with respect to that particular video, I'm going to instruct you are to disregard it and not consider it at all in your deliberations. I'm also advised that the very file name of that particular file was erroneous, and to advise you it was erroneous in indicating an arrest. You need to know, and the parties have stipulated to the court or agreed that the court could provide this information, that the child victim was never arrested in this matter, that what you saw was merely a detention as part of the normal process for dealing with runaways. So again, to the extent that reviewing the file name and seeing arrest was reviewed by you, you are also to disregard that. In an abundance of caution, I'm going to have all the videos on the thumb drives brought back out here. Have counsel review them one last time to make sure there's nothing on these videos that shouldn't be properly reviewed by you at this point, so that we don't have this problem again. While we're getting the testimony of Fiona Ferriter queued up, you can continue your deliberations. Before I let the jury go, is there anything that either the state or the defense wishes me to instruct the jury on at this point? Okay. All right. So that concludes my instruction on this. When you get back there, Mark, just collect all the videos so we can bring them back out. As soon as I'm comfortable that everything is on those videos that you are permitted to see, we'll send them back to you, and then you can continue your review. Thank you. And you may return to the jury room.
So this deliberation might take a while. I don't think we're going to get a verdict anytime soon. The picture was of the child. When he ran away, they found him on the school campus. When they found him, they temporarily detained him, put him in handcuffs, just to make sure he wasn't dangerous. They had no idea, that it's kind of standard procedure. Put him in the back of the cop car, took him to the police station. Nobody knows why it happened, but the cops do what cops do, just to be safe. And then he was talked to and everything else. But there was a video of him, because the news was there and everything else for some reason, being put in handcuffs and led to a cop car. So it makes it look like he did something wrong, when in fact he was the runaway. He was the victim. They were bringing him in. And that was the whole thing they're talking about. The other thing they just discussed is the jury has asked to re-listen to the testimony of the sister, which I believe was the very first person to testify, if not the second. Very difficult to hear because it was in the other room. I had to enhance the audio a lot. So that's, they're working on queuing that up, was the other thing they said. Yes, the cops put him in handcuffs, but very, very temporarily.
All right, everyone may be seated. I'm going to remain on the bench till we get these videos back, and I'm going to personally monitor that each thumb drive is being reviewed, and that both sides are in agreement that what goes back is proper for the jury to review. And again, I note that this should have been done before it ever had gone back, but let's make sure we don't have this situation arise again. From 10G, piped into 10G, and everybody else's voices should be stronger. Danny, just make sure they're clear on the instruction, because it sounds to me like they're confused. Okay.
All right. Do you want me to stay live, or do you want to go back and finish the opening statements?
Okay.
I promise I'll not screw up my watch this time.
Oh, okay, thank you. Okay, thanks. She has IT there, she's IT there at her door. She said that, that was the testimony from 10G.
Recorded in 10G, not the testimony that was taken in 10G and recorded in 11A.
She said she understood what I was saying, so I think something with the Zoom possibly she was saying?
Should have zero effect because it's live testimony in 10G. Zoom should have zero effect on it.
Tell me they can't find the recording.
You're comfortable, they understand that we're looking for the recording of 10G. That recording for that courtroom, not the simultaneous recording in 11A at the same time. Okay. All right, so where are we with the review of the exhibits? Okay.
Wade Myers was the forensic psychiatrist that the prosecution called. He testified day 3, I believe. Very
Let's do a
long
test of
testimony.
10G. I mean, I know they have to go in and clean it, but just to do a sound check, you go into the 10G recording and just play it here so we can see if there's a difference.
Tiff, I had to take most of it down.
Without them doing the work they need to do, because I know they need to get it ready for queuing.
I'm curious if there'll be some kind of sanctions after that.
I'm just concerned they're not working on the right recording.
The judge agreed to do the sound check of the 10G recording. Yeah.
Yeah, he's Boston University. He's the head of their forensic, whatever, department.
17? That is acceptable, but I want you to do a sound check and a video check with the jurors. Video's fine as far as distance. And if you have any problem with sound, raise your hand so I can order those police fine. All right, that's good, Ms. Loki, you may proceed.
All right, so let me.
I think you're a little soft spoken, so because we're dealing with this mic, we're just gonna turn you speak as loud.
Okay.
You said you're 17 years old?
Correct.
Nervous about being here today?
Yeah.
All right, that's much better than what I heard the first time around.
Is it embarrassing to be here and have to talk about these things?
A little bit, yeah.
Yeah.
You're nervous.
Ms. Loki, I'm gonna have to have your assistants, make sure she does everything she can to project, because she does, has a very soft voice and it's not coming.
Can you all hear that?
I don't want her to hear. So, Ms. Barrow, as best you can, you have to feel like you're shouting, make sure you project, okay, you understand me?
Yeah, I understand.
That's the recording we need because that's the loud one.
Go ahead, Ms. Loki.
When you are nervous and just do a little bit, is that the nervous thing? that you have?
Yes, I get nervous, so I do that.
I can hear her fine now.
Okay, we can either watch this live or I can go queue up the recording of her testimony that I enhanced the audio on. Tell me in the comments what you want me to do.
5 minutes.
5 minutes, okay, all right. But that was definitely the recording that, I don't know, I could tell a difference in her voice. Big time. Did it sound like the same thing to you? It did not sound like, I agree. Yeah. Do we recall how long Fiona Ferriter's testimony was? 2 hours? Yeah, that's what I thought. Recording will be able to tell us when they start playing it, right?
Yeah, I'll have
Yeah.
to-
Okay. All right, so I'll remain here. Still waiting on the approval of the exhibits, and then it sounds like it's only 5 more minutes for the queuing.
There is one that should have been there. Like it's in it was due. One of the state videos.
That was 17, right?
17 had to have one here, but we corrected it.
Okay.
It is in the case.
And just so everybody knows, I received the question from the jury, can we hear Fiona's testimony? This question will be made a part of the record. However you handle jury questions, you handle it in that fashion. What do you normally do? Just make it part of the file? That's all.
Okay, I'm going to go back to the defense's closing argument until
It was his room.
they start
And if
playing
you
back.
look at the videos in State's Exhibit, I think it was 16, you can see him doing things in his room that have nothing to do with being in trouble. He is, there's one video where he's FaceTiming a friend and showing them his room to show kind of where he lived. He's playing games. He's playing with Legos. There's a video in there where Peace comes in and tries to play Legos with him, and he says, no, I want to play alone right now. And also testified that that room was not always locked. It was locked in the evenings when he was asleep, and it was locked if he was in a timeout. The state also mentioned that, you know, this narrative that this was a secret. The Ferriters hired a contractor to build this room. It was not privately done by them. They also had the garage door open for much of the videos that you watched yesterday, where one was coming in and out. And so this is not some sort of secret. The teachers knew. There's emails back and forth about Rin's behavioral issues. The fact that Rin had restrictions that other kids did not have or that his siblings did not have was not a secret.
Sustained.
The state's expert characterized, and the state's been characterizing this room as a cell or a box. And I showed you this photo. It's a room with a desk and a bed and toys, and it has stuff on the walls until we took them out or they were taken away from him because he was in trouble. I want to talk to you about the bucket that was placed in the room. Tim says to Rin in one of the videos that you watched it was one of the videos that the state presented, so it was a couple days ago, it was last week. I don't want you to use it. Call us so that you're not using it. Throughout that 6-week period of time, it is used 2 to 3 times in total. What it is not is deprivation of a bathroom. It is a terrible solution.
Did she really just say he didn't want her to use the bucket, but yet every morning when he walks in, he asks if the bucket's dirty?
To wanting to make sure
It's so messed
that
up.
in the middle of the night cannot get out of his room. Because as you heard Tim Ferriter say in the videos, he is running away. So much so that he needs to place a monitor on him so that he is not running away in the middle of the night, telling people that he's someone he's not, and putting himself in danger. You can see in the videos of the sort of timeouts that runs in, and you can always tell because they're always like, do you still have a bad attitude? Or you don't get your Chromebook for this. You can tell in the videos what's going on that day with the family. And they come in every 15 to 30 minutes, and you can see those in the videos, and they say, do you still have a bad attitude? There's one video where Tim actually lets him out of the timeout because he says, you know what, I feel, I'm not in trouble anymore. So this is on January 23rd at 7:10 p.m.
Okay, Sean. So did you get mad when she checked your pockets?
No.
So don't get rid of anything on that because you earned that. Okay? It's a nail there. It's in the ground there.
That's what I know.
Okay, good. Okay.
So throughout the videos, you'll see this happen, that they're checking in on him. They're saying, okay, are you still going to act out if we let you out of the room? And that happens to children all the time when they're in a timeout, that they have to act appropriately. They have to come out without a bad attitude.
You can take that evidence back into the jury room and then bring the jurors out for the replay of a portion of the Fiona testimony at this point. And just out of an abundance of caution, we're sure that the proper verdict form got sent back, right? Well, I had two verdict forms on my. Nope, it's the incorrect verdict form. It doesn't have the lesser for count 3. Let me take a look at it. This is the one that I'm told by the clerk they have. Come take a look at this. That's not as the lesser. Just take a quick look at that.
Are you bringing him out or not? I have my edited video queued up. If there's issues with you guys hearing it, let me know and I can switch over to that. He said their video was about an hour and a half, but I looked at mine and mine said 36 minutes.
I'm glad that I asked.
By the way, the defendant's wearing like a bunch of big, the word I would use is gaudy because they're very chunky, big gold rings. And I actually was able to get a screenshot of them the other night and look it up. And it's that, can't remember the name of it. Who's Irish? The Irish with the hands holding the heart and the crown. Like a big, chunky gold one. He takes his Irish seriously.
All right, everyone may be seated. All right, so first order of business is we do have the testimony of Fiona Ferriter queued up that was held on October 3rd. Her testimony was over 2 days. Once you hear the October 3rd testimony, it'll take about another 10 minutes for the recording room to queue up October 4th, and then I'll bring you back out here for the remaining part of that. The other thing is, I don't want to know anything about your deliberations or discussions at this point, but what I need to tell you is the verdict form you have in there
Yes.
needs to
Thank
be
you.
destroyed. I need to send back another verdict form that is the proper verdict form for this case. So when I send that back, destroy the other one, throw it in the trash, or give it to my bailiff, and he can make sure that no one views it if you've written on it or anything. I don't want to know. But I am sending you back with a corrected verdict form. So you'll complete that as, in your collective unanimous determination, you need to complete it. But at this point, I don't know anything about the discussions or deliberations. I'm just simply informing you that a corrected verdict form is going to be sent back to the jury room, and that'll be as soon as you go back. Okay, so we're at the point where I'm going to go ahead and instruct recording to begin the replay of the testimony of Fiona Ferriter. The first part is about 30 minutes, I'm told, and then the second part is about an hour. So it's about an hour and a half of testimony. All right, Madam Clerk, you can go ahead and begin with the replay. And I can't vouch up front for the audio quality. We've been trying to work through that and making sure we're getting a recording from 10G, but it's the best that we are told that they can do through recording at this point. So you may proceed, Dana. And are you getting feedback?
Hopefully you're ready to call your next witness. Okay, at this time I'm going to have the clerk and corporate 3G, if you could go ahead and administer the oath to Ms. Ferriter.
I can increase the volume, but it runs the risk of feedback, so if I close
Ms. Ferriter, you may begin your convenience.
And what grade are you currently in? 12. Now, tell us a little bit about
Ms. Goldberg, I have not heard her last few answers. Let's do a mic test on her.
Let me know how the volume and hearing is if you need me to switch to the other version.
That is acceptable, but I want to just do a sound check and a video check with the jurors. Video's fine as far as distance.
This might be clearer because it's a recording from the room versus playing through, but
All right, that's good, Ms. Goldberg, you may proceed.
I think you're a little soft spoken, so because we're dealing with these mics, we're just going to try and you speak as loud as possible, if that's okay. Okay. So you said you're 17 years old? Correct. You nervous about being here today? Yeah. Is this a topic that you like to talk about? Nope. No. Is it kind of embarrassing to be here and have to talk about these things? A little bit, yeah. When you're nervous.
Ms. Goldberg, I'm going to have your assistance make sure she does everything she can to project, because she has a very soft voice and it's not coming. If I'm not hearing it, I know my hearer's not hearing it. So, Ms. Meredith, as best you can, even if you have to feel like you're shouting, make sure you project, okay? You understand anything? Yeah, I understand. All right. Go ahead, Ms. Goldberg.
When you are nervous, I noticed you giggled a little bit. Is that a nervous tick that you have?
Yes, I get nervous, so I do that a lot. Yeah.
Now, we're here to talk, you know what we're here to talk about, more or less?
Yes.
I want to talk a little bit about how your family was made up in January of 2022. So that's right when you moved back to Florida.
Okay.
Who was part of your family at that point?
So my parents, my sister, and my 2 brothers.
What were your parents' names?
Tim and Tracy.
And tell us about your siblings. What were their names?
Ronan and Noah and Pierce.
Who is the oldest sibling in your family?
I am the oldest.
Who's second?
That would be Red.
Yeah, I think you were telling us about the makeup of your family in December of 2022. I asked you, you said you lived with your 2 parents. What were their names?
Timothy and Tracy.
And you said that you live with 3 siblings. Tell me the 3 siblings' names.
Ronan, Nola, Pierce. Yeah, Ronan, Nola, and Pierce.
And you said that you were the oldest sibling. What's the next sibling in the age order?
That would be Ronan.
And then who comes next?
Nola.
And then who's the last?
Pierce.
How close in age are you to Ronan, approximately?
2 years?
Okay, so you're 2 years older?
Roughly.
Okay, so you're 17 now, almost 18?
Correct.
And so that he's about 15, just turning 16 approximately?
16 years, yes.
Yeah, he just turned 16?
Yes.
And how far away is between Ronan and Nola in age? If you don't know, that's okay.
I'm not entirely sure.
Are you guys kind of relatively close in age?
Yeah, we're all relatively close.
Within a year or 2 of each other?
Correct.
Were you close in grades in school?
Correct. Yes.
And how about Pierce? Is he close in age?
No.
Okay, how old is Pierce now? Approximately.
I want to guess 4.
Okay, so he's kind of, through much of this, was a smaller baby or a toddler.
Yes.
Okay, while you and your sister Nola and Ronan were much closer in age.
Yes, we were.
Were you originally born in the United States?
No.
Where were you born?
I was born in China.
Okay. How did you end up coming to the United States?
I was adopted.
Okay. And who were you adopted by?
Tim and Tracy.
Do you know how old you were when you were adopted?
No.
Were you a baby or a toddler?
I could walk, sort of, so maybe in between.
Okay. So a little though.
Yes.
Now, do you know whether or not your brother Ronan was born in the United States?
Yeah. No, he wasn't born in the United States.
Do you know where he was born?
Vietnam.
Was he also adopted?
Yes.
What about Nola? Was she adopted?
No.
And Pierce, was he adopted?
No.
Now, you said that in January in 2022, everyone lived together. And where did you live? What city did you live in?
We lived in Jupiter.
In Palm County?
Yes.
Now, growing up, in the time that you were living in Jupiter, maybe one before, who was kind of the rule maker for your parents?
Timothy, my dad.
Was Tracy involved in enforcing the rules or making the rules?
She helped support the rules.
Okay. But who was the one that dictated what the rules and what you had to follow?
Tim?
I think so.
If you had a dispute or disagreement about a rule or whether or not it was fair, is that something that you could talk about with him?
Not exactly.
Okay. Why is that?
Because he would reason us out of it, or I just wouldn't be able to say anything.
Was he the disciplinarian in the house?
Yes.
Now, I want to talk about, you said in January of 2022 you guys lived in Florida. When did you come to Florida?
We moved roughly in December. I'm sorry, the years are a little confusing.
So I think we said January 2022 was when you were with your family, when you guys lived together as a family.
Correct.
Did you move that December right before?
Yeah, December previously.
Okay, so that would have been December of 2021?
Correct.
So the time frame that we're talking about, is that like 5 or 6 weeks?
Roughly.
That you lived in that house in Jupiter?
Yes.
Okay. And you moved to Florida. Where did you move from?
We moved from Arizona.
How long had you been in Arizona at that point?
Approximately 5 years.
Prior to Arizona, where did you live?
Florida.
So this was your second time coming back to Jupiter, Florida?
Yes, within that time frame.
When you lived in Florida before, was that like elementary school age, much younger?
Yes, up until 5th grade.
Now, when you moved back to Jupiter, what neighborhood did you move into?
When we moved back?
Yeah, in
Egret Landing.
What type of house was that?
It was a small 1-story house.
Okay. Single family home?
Correct.
How many bedrooms did it have?
3.
Who had the bedrooms?
So the master bedroom were Tim and Tracy. Nola and I each had our own bedroom. And then, yeah, I guess if you want to count the one in the garage as a bedroom, then that's where, oh yeah, no, sorry. Pierce had his bedroom in the office. They made that into his own room.
Okay, and you said that there was, if I wanted to count something in the garage. What do you mean by that? What was in the garage?
They had a room built for Ronan.
Who had it built?
My parents.
Okay, so Tim and Tracy had that room specifically built into the garage?
Correct.
Is that room already there by the time you moved?
I don't remember.
Okay. But was it there at the very least shortly thereafter?
I saw it, at least.
And when we say that it's in the garage, was everyone else's room in the main house?
Correct, yes.
And Ronan was the only one that had to stay in the garage?
Yes.
Now, I wanted to show you what has already been marked as evidence and shown to the jury. There's some pictures of your home.
Okay.
And so I want to see if you recognize any of them. You mentioned that you had a bedroom. I'm showing you what's been pre-marked as evidence as state 7A and F. Just take a look at it and tell me if you recognize whose room that is.
Yeah, that's my room.
Okay. And now I'm going to show you what's been marked as evidence as states 5A through D. It's another bedroom.
Okay.
Bedroom is that.
That would be Nola's.
And then I'm going to show you what's been marked as evidence as states 4A through D. You might even flip because it wants a close-up. It's fine to do that.
Yeah.
You recognize what room that is.
Yeah, so this one's Pierce's room.
And we see some mattresses on the floor there. Is that how it was when you lived there? Were there mattresses on the floor in Pierce's room, or was there just a crib in there?
There was a lot of things in there. I can't remember specifically.
Is that a place where like Ronan slept?
No.
Okay, so just Pierce slept in there by himself?
Yes.
Now I'm going to show you what's been marked as evidence in state 6. Tell me what that shows.
The bathroom.
And I'm going to show you what's been marked as evidence in state 9. What does that show?
That's the garage.
And in state 9, you said that there was a structure built that your parents specifically built in the garage. Can you see it in that picture?
Yes, it's behind the racks.
Okay. Is that white building?
Yes.
Okay. Let's talk about
Are you freaking kidding me?
that white structure that's in the garage.
Yeah, that little.
Did it have any access?
Tornado warning. Lovely. Sorry, guys. Give me 1 second. What the hell is going on? Well, it's not my internet.
Yes.
Was your sister Nola allowed?
Sorry.
Yes.
What about snacks? Was there food freely available to Ronan in the kitchen?
No.
Would he be allowed to go and take a snack out of the fridge?
No.
What about get a drink of water if he was thirsty? Is that something he could be allowed
You
to
could get
do?
maybe water if someone watched him.
Only if someone watched.
Yes.
And only if he's out of the room.
Yes.
Were you allowed to take a snack if you were hungry?
Yes.
Was your sister Nola allowed to get a snack if you were hungry?
Yes.
Were there times that you would receive special treats, like desserts or snacks?
Correct. Yeah.
What would happen in those instances? Would they be shared with all of your siblings?
There were usually rewards, and usually Nola and I received them. It wasn't often that Ty would also receive them.
Okay. Are there some times that once in a while he would receive a reward?
Very rarely.
But were there times where you and Nola were getting a reward and Ty was not included?
Yes.
Having special treats?
Yeah.
Are there times through the
you know, in this household growing up, were you someone who was observant of how your parents treated your other siblings?
Yes.
Did you watch and listen to things that were happening
Yes.
throughout your childhood?
I did.
Are you an observant person?
I would consider myself to be.
Did you ever see Ty or Ronan get punished?
Yes.
Was the type of punishment that Ty or Ronan got the same type of punishment that you or Nola would get for the same type of conduct?
No.
How was it different?
It was either more extreme or something completely different than what we would have seen.
Were you ever locked in your room or prevented from leaving?
No.
Did you ever have to go to the bathroom only in a bucket?
No.
Were you ever required to be alone in your room in the dark?
No.
Were you and Nola allowed to have phones?
Yes.
Were you allowed to play games on your devices?
Yes.
Was Kai allowed to play games?
No. Not unsupervised.
Was he allowed to have a device?
No.
Now, you said that you saw Ty through your time in Florida or Ronan get punished. Did you ever see him get punished for little things?
Yes.
Like what?
For me, it'd be just not answering questions. Maybe he plays a little too rough with one of us, or he talks back.
When you say he wasn't answering questions, what do you mean?
Let's say he did something wrong and they asked him about it. He wouldn't say anything. He just wouldn't answer them.
And then what would be the response to that?
If he didn't answer them to a certain point, he'd be sent to his room. Or if he did answer, he'd still be sent to his room.
When he's sent to his room, is he then allowed to leave?
No.
Is he locked in there?
Yes, he did leave. I don't know if he was locked all the time, but I know he wasn't allowed to leave.
Did you see both Tim and Tracy force him into the room? Make him go into the room?
I've heard both of them tell him to go to his room.
And did you see both Tim and Tracy involved in the punishment and discipline?
Can you be more specific?
Well, there's some things that one person did or the other person did, but were they both?
They were both involved with the punishment.
Now, over time, growing up with your brother, did you notice him become less communicative?
Yes, he shut down.
Did you notice him over time, especially toward the end, become more withdrawn?
Yes.
Did he smile less?
Yes.
And that's something you noticed kind of as his sibling?
Yes.
Now, I want to talk about specifically right now the time in Florida. What was your observation about kind of how often he was in Florida?
How often he was in the room?
Yeah, did you see him around the house very often?
Not inside the house.
No.
More so outside.
Okay. Tell me about that. What would he be doing outside?
Yard work, moving the outdoor furniture.
So when he's outside, is it like that he has an opportunity to freely play?
No, it's not. It's not for entertainment.
Okay. What kind of yard work is he doing?
At the time we were moving in, so it was mostly moving supplies outside of the house.
Okay. Was there some yard work or landscaping involving shelves that he was required to do?
Yes.
Okay. Is that something that you were required to do?
No.
And did you see him doing that?
Yes, I did see him moving the shelves.
And you said that you would observe him outside. When he was told to go outside, did he have the free option of coming back into the house?
No.
How would that work?
So if he was put outside, one of them would know that he's outside. One of my parents would know he's outside, and then if he got done with work, he'd come and wait for them to let him back inside.
Okay, would he be allowed to just come back in?
Not unless someone was watching him.
Okay. And are there times when he would be locked out of being allowed back in the house?
Yes.
And then when he was let back in, would he then be able to relax around the house, or what would happen?
Not really. He'd either go to his room or just go somewhere to be monitored.
Okay. Now, in your house, did you eat meals with him regularly?
No.
Where would he be while you would be eating?
Most likely in his room.
And what about when you would get home from school?
would he be with you doing homework in the kitchen or the living room?
No, he did most of his homework in his room. I didn't see him very often.
You didn't see him very often out and around the house?
Around the house, yes.
Okay, so when you saw him, when he was home and you were home, for the most part, was he one of two places?
Yes.
And what are those two places?
Room or outside.
Were you allowed after school to come and go freely around the house?
Yes.
And your mom, was she around during those times of the day after school?
Yes.
She didn't work?
No.
Were there times that the defendant, Tim, in this case, was also around?
Yes.
In the house?
Yes.
Would he sometimes do stuff with either Pierce, you, or Nola? Like after school, would Tim or Tracy do things with you all after school occasionally?
Maybe eat meals. I can't think of.
Okay, but Ronan wasn't with you when that happened?
Not often.
Now, when you say not often, was there one or two times that he was out and allowed to eat meals?
He was sometimes. Sometimes he was.
Majority of the time.
Not that enough that I can really recall.
Now, you, at that time, were you involved in any activities at school?
I was here in Florida. I was a part of the marching band and band in general.
There were some times that you had football games or games that were related to the marching band.
Yes.
Sometimes on those occasions did your brother come to the event?
Not that I can recall, but
where would he be during those?
If my parents were coming to the event, he might have been with them or he might have been at home.
And when he was left home alone, when your parents were at your event, was he allowed to be out freely in the house?
No.
So were there family events that you or Nola went to where your brother is left home alone at the house?
Yes.
Did you personally even get the opportunity to see him very often during those 6 weeks in Florida?
Very rarely, like passing outside maybe, or through the window.
Even when he was at home?
Yeah, so I would see him like maybe he's moving yard work, I'd see him through my window, or maybe he did briefly come in the house for food or whatnot.
Now, was there a time in Florida where your brother ran away?
Yes.
And do you remember that happening?
Yes.
Was it over a weekend?
I believe so.
Okay. And what did you end up staying at? What kind of happened when he was gone? Where were your parents?
So I was left home alone. I believe Tracy was with Nola at a softball tournament, and Tim was, as far as I know, not present in the house.
Okay. So he's out of town, maybe?
Yes.
And you said Tracy left.
Yes.
Where did she go?
I believe she went with Nola to softball tournament.
Was that like in Jupiter, around Palm Beach County, or was it out of town?
I don't remember.
Okay. But were you home alone?
Yes.
While your brother was missing?
Yes.
Were you allowed to let him back in the house?
No.
If he came?
No.
Now, I want to talk for a second about another time frame. And Your Honor, now would be the appropriate time to read that instruction.
All right, so ladies and gentlemen, I have an instruction law that we get at this time. The evidence to be reviewed on FF and YF concerning other crimes or acts allegedly committed by the defendants will be considered by you for the limited purpose of proving motive, opportunity, intent, preparation, plan, knowledge, or corroborating the testimony of EM, and you shall consider it only as it relates to those issues. However, the defendant is not on trial for a crime, wrong, or act that is not included in the information. You cannot convict the defendant for an offense he is not charged with. Instead, he can only be convicted of the crime for which he is charged.
Now, I want to talk with you about, we talked about kind of the time frame in Florida. Prior to Florida, you said you lived in Arizona.
Correct.
Tell me about the house that you lived in Arizona. What city did you live in?
We lived in Tucson.
Okay. Tell me about the house you lived in.
It was a one-story house.
How many bedrooms did it have? Tell me about that.
So there were 4 bedrooms.
When you first lived there, who were the bedrooms assigned to?
So when we first initially moved there, it was Ronan, Nola, and myself.
And then did your
And my
parents have
parents, yeah, they had their master's bedroom.
So you said your sister, your brother, and you each had an individual bedroom?
Yes.
And was your brother's bedroom inside the house?
We're talking about Ronan?
Ronan.
Yes.
Now, how old approximately are you when you kind of first moved to Arizona?
I just finished the 5th grade, so I don't know what that age frame is.
Okay, so you're in about the 5th grade?
Yes.
And Ronan is younger than you?
Yes.
So he's in the 3rd or 4th grade
Yes.
at that time?
Oh, wait, no, moving?
When you first got to
Yes,
Arizona?
we had just, yes, sorry.
So is it right to say that he was probably in the 3rd or 4th grade
Roughly.
at that point, elementary school?
Yes.
Okay, and Nola also in elementary school?
Yes.
Now, at that point, you said that he had his own room.
Yes.
That room, was it like an ordinary, regular room, or was there anything different about it?
No, it was basically a mirror of Nola's room.
Okay. Could he go and come freely in that room?
Yes.
Okay. At some point, was there any kind of lock placed on that room?
There was a latch.
Tell me about that.
There was a little latch attached to the top of the door frame. It had a little pin keyhole thing.
So tell me, what does that mean for the person that's inside the room?
He couldn't come out.
Okay, so it could be latched from the outside?
Yes.
Did you see that there were times when he had a room in the house that it would be latched from the outside and he'd be locked in that room? Would he be locked in that room in Arizona?
Yes.
Did that room have a bathroom?
No.
Now, is there at some point a time where he no longer had a room in the house?
Yes.
Tell me about that.
When our youngest brother Pierce was born, they had a room built into the garage.
Okay. Tell me about the room that was built in the garage.
No windows. It had no windows. It had an AC unit, a bed, and sometimes a bucket, or sometimes his belongings were in there before they were taken out.
Tell me about that. Was there times, how would that happen?
So like about the items in his room being taken out. If he got in trouble, if something happened, they would get moved out all the way out of his room, or if he had like decorations, when he would get upset, he would take them off the walls.
And when you say they would take everything out of the room, what would be left in the room?
His bed and a small desk where he would do homework.
Now, you mentioned that the room was built into the garage. Was that house the same as the Florida house? Like, was it all on one level, or was it something different?
So the Arizona house?
The Arizona house.
It was all one floor. The garage just had steps going down to it, but it was all one level.
Now, that room in Arizona, did it have a bathroom attached to it?
The Ty's room?
Yeah.
No.
Did it have any windows?
No.
Did that room lock from the outside?
Yes.
Did that room have any kind of smell?
Yes.
Tell me about that.
It did not smell good.
How come?
He had his bucket in there, which he would use to go to the bathroom. And sometimes if he didn't have the bucket in there, it would just be on the floor.
Now, were there times in Arizona, like in Florida, where your brother would be in that room for long periods of time?
Yes.
Tell me about that.
It's roughly the same idea as the one here. When we did it in Florida, he got in trouble, get sent down to his room, but it's more of getting sent down. More often he was getting sent to the room.
And then how long would he be in the room for? Would it be long periods of time?
It would be long periods of time. I can't say off the top of my head.
Are we talking like all day?
Can I just say there were some days that I didn't really see him that often?
Yes. And so if you didn't see him that often, was he like not at the house, or where was he?
He was in his room or again outside.
So was the situation in Arizona similar in that he spent a lot of time in the room by himself?
Yes.
If he wasn't in school, Where was he most of the time?
Are we talking about in Arizona?
In Arizona.
In Arizona, outside doing yard work or in his room.
Now, we talked about in Florida, when he's outside doing yard work, he couldn't just come back in. Is that the same in Florida?
Yes.
What would happen? Where would he just stand outside, or how would that work?
Yeah, so if he was doing yard work and he finished, he'd come stand outside and just wait, or one of them would go meet him outside. Because by them, I mean my parents.
Okay. Was he allowed to just come back in himself?
No.
Would the door be locked?
I can't.
Okay, you don't know whether or not it was locked.
I don't know.
Okay, I don't want you to speculate, but was he allowed or freely able to come back in?
No, not without supervision.
Okay.
I have a quick question that just occurred to me. So these other children saw this behavior and they were treated differently, but is this all the other 3 children? Are they going to like grow up thinking that this is how you treat a child when they misbehave? Like, I never thought about the impact it had on the other children because in my mind they were treated good, so it was good. What do you guys think about that? Oh, don't even. Oh, fuck. I'm sorry, guys. Okay, I'll never hit pause again, I promise. I promise I'll never hit pause again. Come on, buffer.
I want to say.
So, was it
YouTube hates
approximately
me.
how many years do you think was the special room in Arizona? Just an estimate.
Oh, like how
How long before you moved to Florida was he kept in that room?
So the one in Arizona?
The one in
Sorry.
Arizona, before you came to Florida.
I think Pierce was roughly 2 when we got here, so maybe more than a year.
So approximately 2 years.
Roughly.
Roughly.
That he's been in a room. That's not in the main
before
house.
you came to Florida.
Yes.
Okay. And how old were you when you came to Florida?
So moving from Arizona to Florida.
How old were you?
So, I'm sorry. I think I got confused. Wait.
You think the lock is okay?
Okay. So when we moved to Arizona, yeah, I had just finished the 5th grade, and then when we moved back, I was in the middle of my sophomore year.
Okay, so you were in high school.
Yes.
When you came back to Florida.
Yes.
And your brother was in middle school.
Yes.
Now, we talked a lot about your brother being in the room in Arizona. Were there times where you were concerned about whether or not your brother was getting food or being fed regularly?
Yes.
What would you do when that happened?
If I saw there was a plate for him, sometimes I'd be able to take it and just write it down to him really quick. And otherwise, I really couldn't do anything.
And when you say you brought it down to him, where would you have to bring it down to?
To his room downstairs in the garage. This is Arizona, right?
Yeah.
Yeah, so downstairs to his room there.
Are there times over the course of when you were living in Arizona that you ever saw your father, the defendant, be physically aggressive towards your brother?
Yes.
Tell me about that.
He would grab him by the back of the neck and just kind of haul him down to his room. That was the most common one that I saw.
Would you be able to see what was happening once they're down in the room?
Once they're in the room, no.
Would you be able to hear what is happening?
Yes.
Tell me what you heard.
I would hear him curse at him, yell at him.
And you saying I would hear him curse at him?
Sorry, I would hear Tim yell at Ronan.
And would you hear him curse at Ronan?
Yes.
Okay. What else would you hear?
I would hear the sound of contact, so like slapping or hitting or something. And then I'd also hear my brother scream.
Now, during these interactions, are they is Tim, the defendant in this case, like rationally explaining or calmly explaining the change in behavior or what your brother did wrong?
No. loud, and it didn't really seem much like an explanation. It just felt like he was just shouting at him.
Was your brother in trouble with your parents or on punishment with your parents a lot of the time?
Yes.
Did it seem like he basically was always in trouble?
Yes.
Did it seem like even when he did things that were positive or appropriate, that was acknowledged?
Objection, speculation.
Based on what you saw?
Objections over.
Objection, I'm just telling the witness to wait before answering.
Up to 18 hours at a time.
Yes, Your Honor.
That objection overruled.
Based on what you saw, when your brother was acting in the way that your parents wanted or doing positive things, was that acknowledged?
Briefly.
Okay. Did it lead to like a change in his circumstances or improvement in how he was treated?
Briefly.
Okay. When you say briefly, what do you mean by that?
It maybe went for a week or so, and then something else happened. He did something else. He got himself in trouble and didn't go back to the way it was.
Was the way that he got in trouble, to you, did it seem proportionate to what you knew he got in trouble for?
No.
Did it seem extreme?
Objection, relevance, her opinion.
Sorry, didn't you hear that objection?
It was relevance, Your Honor?
Relevance as to her opinion.
All right, overruled. Go ahead, Ms. Copeland.
You can answer.
Sorry, can you repeat it?
Yeah. Did the punishment seem appropriate or proportional to what he was doing?
No.
Did the majority of the things that he was punished for a minor types of things?
From what I saw, yes.
Now, I want to talk about how your perception of in both Florida and Arizona.
Okay.
Did you ever feel a time that you were unsafe around your brother?
Unsafe as to
Physical harm.
like him harming me?
Yeah.
No.
No. Did you at any time did he ever threaten you or anything like that?
No.
Did you ever see him intentionally cause physical harm to any of your siblings?
No.
Or your parents?
No.
That's all the questions I have.
But
All right, that concludes the October 3rd.
You want to hear the screeching mic? Really? I wish I knew why the internet was so screwed up.
All right, everyone may be seated. Ms. Coakley, do we have the correct verdict form? Mark, can you let her in 10B to get the correct verdict form?
Yes, we are going to start with
That'll be fine.
Debbie.
It's 11:50, 51, so we'll likely start up about noontime.
God, I'm scared to take it off the screen. So we're actually going to start with Debbie, who her mother-in-law went missing in 1975, and they think perhaps that the father-in-law killed her, and another woman around the area went missing as well. So we're actually working on putting that together. We were going to record it today, but then this trial happened, so I woke up and started streaming. So we also have a couple other ones that I'm working on getting put together. So if anybody has any really good stories that are crime or court related that you are interested in telling, you guys have better stories than what is on these streams sometimes. So I'm interested. I want to hear it. And I think everybody else does too. So shoot me an email, DM on Discord, wherever, and you guys can tell me your story. Tell everybody your story. All right, until they come back, let's jump back to closing arguments.
And it's never because, as the state represented, that it's just a bad attitude. If you go through the videos, you will see that there are exact incidents. Stealing a Chromebook, pretending to be somebody you're not, causing an issue at school that it's about. I want to talk a little bit about the actual time that Ryan spent in his room. It's the state's duty to present you with evidence so you can determine what the truth is in any given case. And we talked about in jury selection how the defense can sit there the whole time and not do anything, right? We did not do that, but it's not the burden on the defense. We don't have to cross-examine anybody. We don't have to put on any evidence. We don't have to put on any witnesses. If that had happened, you would have left the long weekend only with the videos that the state presented you, which was 8 hours of only in his room and only getting in trouble. It was not until the defense put on a case that any context was provided to what was going on in this home in a daily basis. It is their obligation to present you with all the facts or the relevant facts.
Sustained.
It is their obligation to present you with.
The objection is sustained. It's not the state's burden to present with all the facts. It's the state's burden to present all the relevant facts material to the case that's being decided by the jury. You may continue, Ms. Murad.
And what is material in this case is all of the evidence of what was happening on a day-by-day type of basis. And what the state said in their closing is that, yes, of course, there were occasional times when he was out, and that doesn't negate any sort of abuse that happened. In a case like this, the reason that it is essential is because it allows you to understand the context of the relationship between this father and this son. Their expert, using only the 40 videos that they provided, testified that every time he was around Tim Ferriter, you would see him tense up and be in fear. And when he was in trouble, that was in fact the case, like any child. But when he was eating freely in the home, or watching football with his dad, or doing yard work that all the kids were doing when they were putting up the different tiki torches, he wasn't acting like that around his dad. Because that is not a constant state in this family. It is not a constant state for Ryan, and it is not a constant state for Tim Ferriter. There are other things that happen during the day. And we went through the videos and tried to provide, let me see, sort of a breakdown of the time that Ronan actually spent sleeping in his room and not in his room. And what you can see is that 43% of the time is spent sleeping. There's one time that they come in the middle of the night, you can see it in the videos, and wake him up to look at his room, and that's on a day that there was a stolen iTouch. I'll show you that. And there are 2 to 3 times that he wakes up to use the bathroom. Other than that, he spends the vast majority sleeping at night. The time that he spends in his room, not asleep, changes over time, depending on if he's in trouble, if he's in a timeout, but that's about a quarter of his day. And the rest of it he spends at school, at home, playing with his friends, doing chess club, and all the other things that kids do. And so I want to go back to this video that the state presented of him being locked out. So the state alleged that Ryan was locked out of his home in Jupiter, and they showed you one video. That is in fact not the case. And so the first video is what the state admitted into evidence from January 22nd at 12:19 p.m. We've admitted as Defense Exhibit 18, and that's available for you. You'll get all the exhibits at the end of the day. The other videos that give context to this one. Because what was actually happening is that Ryan was gardening with his dad from about 9:30 in the morning.
Sustained.
It's in the videos that you can see that are admitted as Defense Exhibit 18. And his father actually brings him water in those videos that are admitted in evidence, and you can see for yourself.
Let me have counsel approach, please.
He gave him water. He wasn't abusing him.
All right, Ms. Murad, you may continue.
WTF.
I'm now going to play one of the videos that the defense put in. Under Defense Exhibit 18, there's 3 that offer context to what's going on here. And you can see that several minutes later, and enters through the back door. And again, this is why this is important. You have to have the full picture of this parent-child relationship in order to make any determination about what the parent-child relationship is. And it does not justify the actions that Tim Ferriter took. That was those were bad choices that he made, and we are not disputing that they were harmful to Roman. What it does not prove is all the elements that the state has to prove, particularly as it relates in what we're talking about now to whether or not there's intent, whether or not it was malicious punishment, whether or not it was torture, whether that's what it constituted. The defense admitted a 14-hour video. We did not show you the entire video because you watched many hours of the state's video. However, the entire 14 hours is in evidence, and what we tried to do is provide, as much as we could, different days and different sort of experiences that he was having. And it's not just relevant to show the context, it's also relevant to show what's actually true about what happened. This idea that Ronan didn't have the ability to eat snacks when he wanted to. One of the videos that we watched, he was watching football and there was a bag of popcorn on the dining room table, and he grabs the entire bag and starts to eat it. This is after the state's expert, Wade Myers, who relied on only 40 of the 21,000 videos, said that this child, and that's part of his opinion, right? Why it's solitary confinement, why he believed it was torture, why he believed it was malicious. He is relying on facts that are not the whole truth. And so, of course, if you only watch those videos or the 40 that the state sent him, you're going to think, as you probably did after watching 8 hours of video, that the entire life of this child is in this room. And that is not true. You saw him playing outside. Prior to January 5th, you see him frequently outside. I know it looks like Tim Ferriter only watches football for a living, but it was December 31st and January 1st, and so there were a ton of football games coming on. If you go later, I think we showed you January 5th, 7th, 9th. You can see them walking outside as a family, playing in the cul-de-sac, playing with people who clearly really loves, fixing up a scooter that he had. That is also the life of this child. Fiona testified, and so did Roy. This is a busy family. I think in every video you saw Tracy running around in the back from, place to place, grabbing pictures. But you have 3 kids that are around 13, 14 years old, all with their own activities, right? Has softball, has band, and at the time had chess club. And so all these people are running around. They are not eating meals at the same time. They are not sitting around their kitchen table excluding who's in his room. And the videos will corroborate that, should you wish to watch 14 hours of video. That is what you will see, that people are running around getting snacks. Tracy, at one point, we didn't end up watching this in the 3 hours that we presented, makes cookies for everybody and partakes in that. You see him in the earlier videos, I think it was December 29th, coming back with little styrofoam boxes of leftovers. Wade Myers and the state are alleging that he had no control over his movement, where he went. And yes, at night, he was in the room with a lock on the door so that he could not get out, so that he could not run away or harm himself or do something around the house or get knives like he did before. That's at night. During the day, he went to school. He was with his family. And there were days that he was in trouble, and we're going to talk about that. And he would be in his room as a timeout because he was not allowed to engage with everybody when he's in trouble, when he gets in trouble at school. The videos, again, it's 14 hours, do get tedious. But the reason it's important is that there are extended periods of time every single day that you see Ronan have full control over his movement, what he's eating, where he's going, walking around the house, playing outside, doing yard work sometimes. We talked about that. Chores like everybody else had in the family. That is a family. That is the life of a child. There are days when you are doing chores that you do not want to do, and there are days that you have to help your dad out with the yard and the tiki torches, and there are days you are chilling on the couch with your dad, watching football. There are days where you are in trouble, in really big trouble, and you are crying in your room because you are so frustrated that either you're in trouble with your parents or you did something that you didn't intend on doing. And it is the life of a parent that sometimes you need help with the random stuff that your wife's making you do around the house. You have your son help you out, that you're running around dropping the kids off so you don't have time for everybody to sit down and have a meal or have a breakfast that is exactly the same or have or make everybody a different breakfast every day. You're dealing with the stuff that your kid did at school. You're getting emails back and forth and having to deal with that. Go to the school, drop the other kid off, and go to work, pay your bills. That is the life of a parent. And sometimes you get frustrated with your kids and you do things that you regret. That is the life of a parent. And that is the life of a child. And sometimes kids and their parents are on exactly the same page, and it is a really good day. And sometimes you couldn't be on further off planets and you are mad at each other. And you say things you regret and you do things that you regret. But that does not make you a criminal.
Overruled.
I want to talk a little bit more specifically about the videos that you saw and what happened during the course of this 6 weeks. So a really important day is January 5th. And you can see from the videos that January 5th was the first day of school. And I want to give you context for what happened prior to January 5th. There's a video in which you can hear Tim getting really mad at him and saying, you just got kicked out of basis. We got to start this school off right. We cannot be in a situation where you are getting kicked out again from school after school. And admitted on cross-examination that at basis, he did in fact jailbreak a school laptop, right? That does not belong to him or his parents. And did violent searches on it that were very concerning to his parents, and that they responded to that because as a 14-year-old child, you should not be doing searches like that. And on January 5th in the evening, Ryan is asked, did he do a search after he jailbroke a tablet? And was there something concerning to mom and dad? So we talked about this. Now, when we get to January 5th, the state presented some of this video. I would like to present all of it. And the state represented that the reason Ryan was in trouble on January 5th was for something as minor as stealing candy. That is not true, and that is not what the videos and the state's own evidence show. So I'm going to go through these one by one. I also want to point out that at this time on January 5th, they moved probably, week 2 before, based on the records. He still has everything in his room. He has his toys, he has his bed, he has his computer, he has all the posters that he likes. This is a time before he got in trouble, and it's a real turning point in this 6-week period.
You gonna play a little bit, or you're tired?
Yeah, we'll play a little bit.
Okay.
So you can see there. You can see there that there is something going on in this corner that Ren is doing, and you'll see more context as we go through that he had something he was not supposed to have. And he was hiding it right and wouldn't be able to check.
By the way, I think that's his sister, the blonde. Somebody was saying it was her sister. Look at the nose. Looks more like his than hers. Although she looks more like his sister than the other one. Who knows? I agree.
You gonna play a little bit, or are you tired?
Yeah, we'll play a little bit.
Now you'll see rearranging the entire desk and bed arrangement.
Look, they treated him nicely in the box. That's what everybody's called it. I didn't make it up. Reggie even called it that.
I don't know, you have to see.
So, at this point, he's moved his desk, right? And we saw in the other videos that they want the Chromebook. It was specifically, you can see Tim when he puts it up on the 5th, that they want the Chromebook to point towards the table. You can see him almost adjust it in that video. And I understand why in any other circumstance that may seem like very unreasonable supervision for a child. A kid should be able to use their devices how they want. However, when a 14-year-old is using their devices in a manner that is destroying school property, that is breaking into the school's IT system, that is doing searches that the parents do not approve of and that are unsafe, then a parent, like Tim Ferriter, decides, I have to remove your technology. And when you use it, you have to be monitored. Because as testified, this is not the first time he jailbroke a school laptop. It happened at his school in Jupiter. It happened at his school in Basis. He broke into the IT system at Immaculate Heart. This is a consistent pattern, and you can't break school property, right? Someone has to pay for that. Someone has to answer for that. And what never happened is that Tim Ferriter called the police or told the school, take my kid to jail. for committing a crime. He said, I'm going to handle it myself. And though he handled it very poorly, as you'll see here, there was a reason for everything that he did. And so we're going to watch these videos, which were showcased by the state, so that you can see what they presented and then previously what was the context to what happened. Because as you'll see, it was not about stealing candy. It was about stealing an eye touch that did not belong to him.
Right?
You want to tell me something? Stand up. Want to tell me something?
What?
You want to tell me what? This is your one chance. Don't look at me like an asshole. You want to tell me something or not?
I have a nightmare.
Yeah, from where?
Blue bed.
Where?
Green bed.
Excuse me?
Green bed.
Stealing again?
What the
I mean,
fuck,
really?
What the fuck is wrong with you?
You're stealing,
so fucking
like,
disappointing.
chocolate, and there's you got so much stuff in your
Give me a
room.
fucking break. You're just such a disappointment. You're gonna lose. I'm gonna take you out of that school, and you're gonna be in this room.
He's gonna be.
You're this close, because I can't trust shit you do. But put the ankle bracelet back on, and then you can try to fucking run away if you want and do all the bullshit you do, but I'm gonna lock your ass down.
You guys those are for my toilet.
Give me a fucking break.
Why are your balls taped?
I'm sick of the bullshit. You're a big boy, you're gonna steal, you're gonna talk to the police, I'm gonna give you a fucking real deal. Okay? You're gonna steal from our fucking house?
Again?
Give me a fucking break, bro. What other shit do you got in here?
Nothing else.
Because you're gonna lose it all in about 2 seconds. Lose every fucking
It's
thing.
all gonna be
this
smashed
shit.
real
Don't,
quick.
I told you not to unplug that fucking thing. Right?
Yeah.
Do you listen to me?
Yeah.
Bullshit, dude.
No, you didn't. You
Just
unplugged
unplugged
it to plug this in, and then you're just a liar, Ronan. Just keep lying. You lied earlier when I asked you. You can't.
Fucking disappointing. You're a big boy, you're gonna steal, you're gonna talk to.
Throughout their closing argument, the state, when showing you some of these videos and Tim's own statement, says that's malice, that's anger. This is how maliciously is defined. Wrongfully, intentionally, and without legal justification or excuse. It later says that the primary purpose of the acts was to cause the victim unjustifiable pain or injury. In every video that you see in this case, you will see that there was a reason for what Tim Ferriter did. And you will also see, in light of the context in this case, that that moment that you saw, those 6 weeks, are a pinnacle of frustration, right? That tone, that frustration that you are hearing is after years of continuous efforts.
I think we watched.
I want to talk next about the child
3 hours.
neglect instruction. In the instruction, one of the things that the state has to prove is that the parent did not provide care, supervision, and services necessary to maintain Ronan's physical or mental health. The state talked about the child neglect instruction briefly. In this particular case, we can see, so for example, the state said that there is no record of any treatment after 2019. As we discussed, that's not the case, and that's not what Dr. Rappa testified to. In fact, Dr. Rappa relied on medical records from about 2019 to 2021, where one was being taken routinely to the doctor. Dr. Stuart Graham testified that there's no evidence of malnourishment. And the reason we felt that was important as the defense is because of this ongoing discussion about control over food, which, as you saw from the videos, is not consistent with the facts. When he was in trouble, he would be given food in his room. He even said, when we talked about the meals, he said he got the peanut butter and bananas on bread, and he said he was a pescatarian. And so I said, so you were given a meal for a pescatarian? And he said, yes. When you watch the videos, you'll see that the family is eating, is out with them, and there are times when he's in trouble and he has to eat in his room. You'll also see that the other kids are not eating around the table without everyone's grabbing and going and running like any family. We talked about his ability to manipulate the air conditioning and how that's not neglect. that there was a safety concern there after he almost started the electrical fire. He went to the doctor routinely. So now we need to talk about whether or not there was a valid legal reason to what happened. And this applies very specifically to the unlawful caging element of aggravated child abuse and to false imprisonment. So under the law for false imprisonment, I want to read it to you exactly. It states as follows: that you forcibly, secretly, or by threat confine, imprison, or restrain against his will, and that you had no lawful authority to do so. Parents do have lawful authority to contain their children.
Sustained. The jury will rely on the court statement of the law and not counsel's statement.
When a parent has a child, right, a really young child, who has to, we're talking about a toddler here, and I don't mean that in a derogatory way. When you have a child who can't be trusted, right, they are contained. And as a parent, you do have a right to put your child in a timeout. You don't have a right for it to rise to the level of abuse, and I'm not trying to suggest that at all. What I am saying is that a parent can make a decision that the safety of that child, and in this particular case, is running away, as you saw from Tim, who was saying, "You've got me forever, but you have to stop. Because if you keep running away and you keep lying to people about who you are, you're going to get hurt in this world." You have the ability, and that's why it's lawful authority, to say, you cannot leave your room.
Sustained.
As to the unlawful caging, that parental affirmative defense applies to the entirety of aggravated child abuse. So when we're talking about whether a parent's actions...
I'm going to overrule that based on prior conferences that the court had with both sides on jury instructions.
applies to the entirety of aggravated child abuse, that parental affirmative defense. And so the decision that you're making is not, would I have done that in Tim's situation, but whether Tim felt it was reasonable to do that in light of the unique circumstances
Sustained.
that he was facing as a parent.
All right, jury's instructed to disregard the last comment of counsel. You may continue, Ms. Moran.
That reasonableness element that you are determining, right, as to what a reasonable parent would do, it is under these circumstances. And the circumstances that Tim Ferriter was facing are different than the circumstances of another person who may be in that chair. The circumstances that Tim Ferriter was facing are important in your determination. Because he had a child who, as Dr. Rappa testified, had no impulse control, wasn't stopping, and who by his own testimony was breaking the rules routinely despite knowing that there were boundaries. And these are not just minor incidents. The state can pinpoint a few minor incidents, but the reality is that their own expert knows that the child had an attachment disorder. That expert testified that there were no suspensions in the record. That's not true, and Dr. Rappa explained that and admitted to that in his own deposition, which Dr. Rappa relied on. This idea that the behavior was so minimal that it didn't matter couldn't be further from the truth. There are doctor's visits as early as 2017, when Ronan was probably 8 years old, documenting, as Dr. Rappa testified to, uncontrollable tantrums that are consistent with having an attachment disorder, of harming other kids at school. There are school records that Dr. Rappa testified to saying this is getting dangerous, and it is not stopping, right? That's what she said. It's that lack of predictability and the persistence that is really important in understanding the circumstances that Tim Ferriter had. Because those are the only two things we can rely on, right? Is that when you ask someone to stop doing something, they'll stop. And that when you, and of course it's a little different with a child, you give them a little bit more room to grow, but there comes a point where that stops too, where it's becoming dangerous, where they're not allowed to run out of the house in the middle of the night, where they're not allowed to steal knives from a location where the knives do not belong to them. The fact that they did not utilize the knife doesn't matter for a 10-year-old. You shouldn't have knives. The fact that you are doing searches on your computer for violent things. You're not allowed to have access to computers if you do that. So those circumstances are unique to Tim Ferriter. And that lack of predictability Dr. Rappa talked about, right? We expect people to act in a certain way. And the thing about that impulse control and lack of emotional regulation is that there is no expectation with Ronan. There are good days and there are bad days, and you see that in the video. There are days where he's hanging out and nothing's happening, and there are days where he is so frustrated he is screaming in his room. Those good days and bad days are consistent based on what Dr. Rappa and Wade Myers testified about with someone with that attachment issue or complex PTSD. That both admit the Ferriters didn't cause. And behaviors and issues consistent prior to 2018. After I am done, the state has the opportunity to have a rebuttal. I do not have that opportunity. This is the last time that I get to talk to you. And so I want to discuss again reasonable doubt. Before I do that, I want to talk a little bit about, the jury credibility instruction. You heard testimony from, and the state talked about how it was consistent with what said. What you will recall about my colleague's cross-examination of and also mine of is that there were things that were either not remembered or misremembered. And I don't think that these kids are lying. I think that as a teenager who has her own life going on and doesn't always remember and doesn't know everything that happened with, right? Her parents are not telling her every single thing. Mr. Waugh had asked her about specific acts that had happened, and she didn't know about them. She also said that he never went to a marching band practice, and we were permitted to admit this exhibit, showing at her marching band practice, that he was never permitted to do homework in the house. And there he is doing homework with her in the house. And the state can say all they want that, oh, these, minimal incidents, they don't minimize this, that, or the other, but it does challenge the credibility of the witnesses. Because Rick initially said that he never got food, that he occasionally was fed in Florida. You can see on the videos that's not the case. You can also see that when I questioned him, I went up to him with his deposition and said, look, when you were in a deposition and sworn under oath, you said you got every meal. And he said, that's right, I agree. So at the end of the day, these are children. And the best evidence is going to be the videos that you see. And I encourage you to watch that 14-hour video as best you can during the course of this. So now let's talk about reasonable doubt. So the instruction that you will get and the judge has read to you, but I want to highlight a portion of it, is this. A reasonable doubt is not a mere possible doubt, a speculative, imaginary, or forced doubt. Such a doubt must not influence you to return a verdict of not guilty if you have an abiding conviction of guilt. On the other hand, if after considering carefully, comparing and weighing all the evidence, there is not an abiding conviction of guilt, or if having a conviction, it is one which is not stable, but one which wavers and vacillates, then the charge is not proved beyond every reasonable doubt, and you must find the defendant not guilty because the doubt is reasonable.
All right, so, Mr. White, you facing cross-examination? Yes, Judge. All right, so you may proceed, sir. Thank you. How are you?
All right, let's go. Go with it. All right, you may bring the jurors out. And this is an hour. An hour. Okay.
An hour.
50 cents.
Jury in ring.
All rise. All right, everyone may be seated. All right, members of the jury, we have the October 4th testimony of Fiona Ferriter queued up. It's about 47 minutes of audio. So with that, Danny, you can go ahead and have recording begin playback.
All right, so, Mr. White, are you going to cross-examination?
Yes, Judge Aaron.
All right, so you may proceed, sir. Thank you.
Fiona, how are you?
I'm fine.
You might be nervous. I'm just here to ask you some questions. If you don't understand anything I ask you, okay, I understand the question. Okay? Let's start with your brother's name. It's Ronan Ty Tan Ferriter, correct?
Yes.
So you've been calling him Ty, right?
Yes.
So if you want me to call him Ty when we're talking about it?
Ronan is fine.
Ronan is fine. All right. So let's go back to Arizona. So some of what you talked about yesterday was Arizona, and some of it was Florida. Arizona, you were there from approximately what year to what year that you remember?
Left around 5th grade, and then we came back in the middle of my sophomore year, so whatever time period that was.
Okay. So you're in 5th grade, you think you were about 10? 10?
Roughly.
Okay. So, and then in sophomore year, how old were you?
Fourteen-ish? I can't. Yeah.
Okay. So you the Arizona years were about 4 or 5 years, something like that.
Mm-hmm.
All right. So you were there and then you came back to Florida, and the Florida time period was, you said, around late December of 2021, and then in this case we're taking it up to the end of January of 2022. So in that time period, so that's about 6 weeks or so, correct?
Roughly.
Okay. So substantially more time in Arizona, obviously, than this last time in Florida.
Yes.
Let me ask you a little bit about your brother's medical situation. You never went to the many doctor visits that he went to, correct?
No.
But your parents went to those visits, correct?
I assume yes.
You don't know if your parent went to a visit for the doctor?
I didn't really.
Okay. And you never obviously saw any of the medical reports that your parents saw, correct?
No.
Correct. Yesterday you said that your brother wasn't allowed to have certain snacks, correct?
Yes.
And you're aware that he was, your parents were trying to curtail the sugary snacks in his diet, correct?
That's what they said.
Okay. So you're aware of that, right?
Yes.
And you didn't go to any of the mental health visits that your brother went to. He was seeing a therapist. You didn't go to those, correct?
When was this?
This would have been in Arizona.
If he was going to a therapist, I wasn't aware of that.
Okay. Good. Which would also mean you weren't aware of anything the therapist would have conveyed to the family in terms of Ronan's condition.
No.
Okay. So let's go back to the food and snacks. Yesterday you said he was essentially not allowed to have food and snacks, but the other food, correct?
Yes.
Were you aware that, did you think your brother at any point looked malnourished or in any way like he was getting too thin or anything like that?
Yes.
And when did you convey that to anybody?
I never said anything.
And are you, you said that about the snacks, that he was allowed to have snacks. Isn't it true you do not know if, when he was hungry, that he actually ate snacks or not? You don't know that.
Repeat that?
Sure. You're unaware that when Ronan was hungry, whether or not he actually ate a snack. You don't know that.
He wasn't allowed to get his own snacks.
You remember you spoke to somebody on the road back on February 1 of 2022, and directing Board of Council, page 55, line 8, as to snacks. You gave a statement on February 1 of 2022, it was not on the road. And in that statement, you were asked, if he's hungry, does he get light snacks? And your response was, I don't know.
I don't know.
You don't know, okay. And you don't know because you're not with Ronan all the time. You're not always watching him. You're at school. You have other things going on, correct? And you're a pretty smart child. You like reading a lot, correct?
Yes.
And you spend a lot of your time in your room reading by yourself, didn't you?
Yes.
Let me talk to you about lights and Ronan. You were aware that Ronan had not been sleeping yet, right?
Yes.
And you talked about a few things yesterday. Some of them were in Arizona, some of them were in Arizona and Florida. You talked yesterday about your lack of contact with Ronan during those 6 weeks in Florida. Remember that?
Yes.
And reality is you were pretty busy doing homework or at school or at your sister's games during that time. And you didn't really have any reason to go to Roman's room, correct?
Yes.
And you spent a lot of your time in your own room reading, correct?
Yes.
You also talked yesterday about Ronan not going to your events, and it was that you must be talking about in Arizona, right?
Yes.
I don't like this attorney, just FYI. I don't know what it is, but something bothers me, the way he talks.
I'm going to show you 3 pictures. Take a look at each. Tell me, you recognize what those pictures are?
Yes.
Okay. And I'm going to mark each one for identification. So the one I put a card on that says number 4, what is that picture of?
U of A bandit.
I'm sorry, say that again?
U of A bandit.
Okay. And the picture marked number 5, what is that a picture of?
A concert.
Okay. And
Now it's a stream.
the picture with the card number 6 on it, what is that a picture of?
Spelling.
Spelling. Okay. All right.
Court is going to sustain the objection as to exhibits 5 and 6. However, the defense is not precluded from using those documents for purposes of refreshing recollection. Mr. Wright, you clear on the court's ruling at this point?
I am.
All right, you may proceed.
So, if you look at the picture where number 4 is, the card is number 4 there. What's that picture of?
Arizona Bandana.
Okay. And do you
All
remember?
right, she needs to restate that. She needs to restate that answer because my jurors did not hear. So just state your answer again.
As loud as you can speak.
Arizona Band-Aid?
Better?
Arizona Band-Aid?
Yes. Yeah.
I'm gonna repeat the answer here every once in a while to make sure we agree or not. So you just said Arizona Band-Aid.
Yes.
And in that picture is you with the awesome hat, correct?
Yes.
And you're holding an instrument.
Yes.
Yes?
Yes.
And what's that instrument?
A flute?
A flute. So that's what you play?
Yes.
You still play the flute?
When I want to.
Okay. And next to you in that picture is who?
Directly next to me is my brother.
Which brother?
Ronan.
Okay. And in front of him is who?
Pierce.
And next to Ronan
Nola.
is Noah. So that's all your siblings in that picture, correct?
Yes.
So they did attend, and Ronan did attend that day, correct?
Yes.
Okay. Now, I think the court already moved it into evidence, but it's my habit, so I'm moving 4 into evidence.
I've already received and accepted 4 in evidence and dealt with 5 and 6
Okay.
already. This objection is sustained, but you can use it for refreshing recollection. So, Madam Clerk, can you consider the court's rulings on that? Okay, all right, good enough.
Show me 5. Do you recognize this picture?
Vaguely.
What do you remember it from?
It was a concert I did.
Okay. So you remember that you attended a concert and your brother Ronan was present, correct?
Yes.
Okay. And then looking at 6, do you remember Ronan now attending your spelling bee? I'm just gonna look at the picture.
I am.
Who's that?
It looks like Ronan.
So do you recall him? Do you recall him attending your spelling bee?
Yes.
Yesterday, you said that Ronan did not do his homework in the house, correct?
Not off. No. Yes.
Okay. And that would include in Arizona, correct?
Yes.
Showing you what's been previously marked as Exhibit 7.
On his attorney's website, she says,
Do you recognize, what is that picture of?
Me doing my homework.
Okay. And how do you recognize that?
What do you mean?
You know it's you because it looks like you?
That's me.
Okay. I just want to make sure. Okay. So that is a picture of you, and who else is in that picture?
There's Ronan in the background.
so I've only heard sidebar arguments on this. Court's going to receive and accept Defendant's Exhibit 7 in evidence over objections.
She says she represents women and children and handles abuse cases against them. So it's kind of interesting she took this case. We can look at that after this.
I don't lose track of that. Yesterday, you also said that Ronan was not allowed to attend family events. Do you recall saying that?
Not all the time.
All right. So he attended
Some family events.
some family events. Okay. And when he attended those family events, those would include trips outside when to things that were like going to see like the Aerospace Museum, for example.
I don't recall the Aerospace Museum, but he would come sometimes.
Okay. Let me show you Defense 8. Do you know what that's a picture of?
I don't remember this.
Okay. So who's in the picture? Anybody remember?
Yeah.
Okay. Do you remember the people in the picture?
Yes.
All right. Do you remember where this picture was taken?
No.
All right. Do you recall taking family hikes, which included Roman?
Yes.
And to Sabino Canyon?
Yes.
Do you recall your family, including Roman, spending time at the Tucson Hotel JW Marriott pool?
No.
Showing you what's been marked for identification as Defense 10.
They're going through
Does
the
that
6
help
times
refresh your recollection?
the kid's ever have fun in his life. So no, you didn't miss anything.
I don't remember this.
All right. Yesterday you said Ronan was not allowed to play outside, correct?
I believe I said not usually.
Okay. But you would be allowed to play outside, correct?
On occasion.
You would play outside in the backyard in Arizona, correct?
If you could call it a backyard.
All right, well, setting aside what you think of the backyard space.
Hold on a second, Dwight. We're getting noise from outside that's interfering with our ability to hear us. Let that pass as trying. All right, I'm going to ask you to restate the last question and give the witness a chance to restate your answer.
My last question, Fiona, was whether you recall Ronan playing outside in the backyard in Arizona.
No, just kidnapping and child abuse. He locked him in a room,
And
especially made room in the garage.
play at times with the other kids in your family.
He
correct?
didn't.
Yes.
He didn't die. He had no physical injuries, actually.
Do you recall all of you kids playing at a friend's house swimming pool in Arizona?
That's too general.
Okay. Well, a swimming pool in Arizona that was not your home, but the home of a family friend.
I'm not sure I'm understanding what you're asking.
Let me show you something and see if it helps you narrow down what I'm asking. Showing you what the mark identification is with fence 12. Do you recognize that location and the people in that picture?
Do you remember that one time 8 years ago when you stopped and went swimming at a friend's house and someone snapped a picture? Like,
I
really?
recognize my siblings, but I don't recognize the person.
You don't have to get a clearer answer from you. I heard you say you recognize.
I recognize my siblings, but I don't recognize the person in the middle between my brother and my sister.
Okay. And your brother, that's Ronan, correct?
Yes.
All right. And you're at a swimming pool, correct?
Yes.
Your house didn't have a swimming pool, right?
Which one in Arizona?
Yes.
It did have a swimming pool.
Okay. Is that your house in Arizona swimming pool?
No.
All right. So so is it fair to say that there were times where you all went out together, including going to friends' houses?
At times, yes.
Do you recall going to Mount Lemon in Arizona with, and that was like a family vacation day, correct?
Yes.
Yeah, it seemed like she was getting a little irritated. Blame her.
Was Ronan, did your family celebrate Ronan's birthdays?
Yes.
And by celebrate, how would they do that? Bring out a cake, everyone, family sitting around the table, that sort of thing?
Yeah.
The room started long before reports of him ever running away.
Ronan was involved in martial arts, correct?
Yes.
And the parents put all the kids, other than Pierce, who's very small, in some activities, correct?
Yes.
And you were involved in track at some point at basic?
I did not go to base.
Okay. Did you ever do track?
Yes.
All right. Was Ronan doing track with you?
Where?
When you were doing track?
I did track in 2 places, here and in Arizona.
All right. Let's talk about Arizona. Did Ronan do track in Arizona?
I feel like all the Arizona talk is going to confuse the jury. And if I keep looking back, it's because my dogs are snoring, and every once in a while it's really loud and scares me.
No. Yes. Well,
So let me ask you about chores. So yesterday, do you remember you saying that Roman would be outside moving shelves?
Yes,
That's here in Florida, correct?
correct.
And that was this current time in Florida from end of December of 21 to the end of January of 22, correct?
Yes,
And the house your parents moved into in Jupiter had in front of it a tree
Yes.
with a bunch of shelves around it, correct?
yes,
And they didn't want the shelves, so there was an effort to remove the shelves slowly and get rid of them, correct?
yes,
And that's what you're talking about that Roman was working on, correct?
yes,
You had chores in the house too, didn't you?
yes,
And so did Nola.
yes,
And the types of chores that you and Nola had would be mostly inside the house, cleaning up, that sort of thing, correct?
yes,
And the types of chores that your brother Ronan had were mostly outside things, right?
yes.
So Ronan had posters in his room at some point, correct?
Yes,
In fact, your parents got those for him for Christmas at one of the Christmases, correct?
I don't remember.
Going to see if I can refresh your recollection of the statement you made on February 1, 2022. Firm Court Counsel to page 24, line 13. Read it yourself. When you're done reading that, let me.
Absolutely. He's driving me crazy.
So there were some posters that your parents got Ronan for Christmas, correct?
Yes,
And at some point, Ronan shredded all of these posters, did you?
we did.
Ronan used to also have a dresser in his room in Arizona, correct?
He did.
And this dresser was taken out of the room, correct?
Yes,
It was because he was ripping his clothes up when he got upset, correct?
yes.
And the dresser was placed just outside of his room.
This is in Arizona, right?
Yes.
Yes,
So in late January of 22, Ronan had run away, correct?
yes,
He had run away at least 2 times before that, correct?
yes, but not here.
In Arizona.
Yes. I don't think it's, yeah, it is here.
And your parents at some point had a family meeting, I think it was when he first ran away, and asked you all how you felt about him running away, correct?
I don't remember.
Referring court and counsel to the statement of February 1st, 22, page 32, line 16, to the end of the page. Review this. Read from this line to the end of the page. When you're done.
Like all of this to try and impeach her, and I'm not really sure it's gonna work. I don't know what she looks like, but she sounds sweet.
They asked you all how you felt about it.
Yes.
And your position was that
As to the answer or to the question? The overrule is to the answer, and overrule as to the question as phrased. You may answer.
I'm going to ask this question.
The question was, what was her position?
No, yeah, the question was exactly what was your position about when they had
Forgot
this
his
meeting, they asked you how you felt about it, what was your position?
Let me be clear, I'm allowing her to state what her position was, not what she said. She could testify as to what her position was, and then not be hearsay, so I'm going to allow that.
Can you repeat what you're asking?
Yes. So I'm going to go back to the previous question where I asked you, they had meetings, and the
That's
first
what he
time
did.
they asked you all how you felt about it. What was your position on that?
On him running away?
On how you felt about that? How did you feel about that? Him running away, yes. First time.
I'm sorry. I'm sorry.
You want me to ask the question again?
No, I heard you. I'm just trying.
Hey, Kathy. It's really bad if she doesn't know how she felt about him running away.
She said, I heard the question, I'm just trying. And she stopped.
I'm trying to think.
Trying to think.
It's 1 p.m.
I'm sorry. When he ran away, I wasn't really sure what to think. I was surprised, but also tried to understand why. I was worried, I guess, is one answer. Is my answer. I'm not sure I'm understanding the question.
All right. I'm going to move on. Is it fair to say that when you would be getting in trouble back then, around the time frame in Arizona, that you didn't often know why he was getting in trouble?
I didn't know the specifics of why he got in trouble.
Did you think at any point that he was being wild or energetic, anything like that?
He was hyper.
Did you ever notice it was very difficult to calm him down once he got going?
Yes.
Did you ever see your parents try to make efforts to calm him down with words?
Yes.
Yesterday you said that Roman got in trouble and things would be taken away from him.
Yes.
Well, were times you got in trouble with your parents, correct?
Yes.
And they would take things away from you, correct?
Yes.
Like your electronics, right?
Yes.
And Roman had an iTouch and that got taken away at some point.
Yes.
And you're aware Roman would steal from inside the home.
Yes.
You're aware at some point he stole other people's credit cards.
Yes.
He in fact stole your money at one point.
Yes.
And you and your sister did not do the same types of things, correct?
No.
You're aware that Ronan was asked to write sentences at some point.
Yes.
And the sentence was usually, I will not steal, correct?
That's one of them.
Another one was, I will not lie.
Also another one.
You talked about the house in Tucson. The address was it 4245 East Havasu Road?
Yes.
Do you remember what the layout of that house was?
Yes.
I'm going to show you something to.
He is so slow. I feel like we could watch another case in between with all his pauses.
So that house, it was, so walk in the front entry, you're in the living room, correct?
Yes.
Why does it matter?
There's a dining room to your left, the family room to your right, and the kitchen is the back on the left.
Yes.
And then if you go to the left, through a door, there's a bedroom, correct?
Yes.
Was that your bedroom? On the
Yes.
left?
Yes.
Yes. Okay. And then if you went opposite your bedroom, down some stairs, you get to the garage, correct?
So the way that was situated is my bedroom, there's a laundry room, downstairs is the garage, and then there's a bathroom.
The bathroom is in the hallway between the garage and your bedroom.
It's on the other end of my, so if I'm looking at my bedroom here, the bathroom's on my right.
Okay. And the other three bedrooms were on the far opposite side of the house from your bedroom, correct?
Yes.
So you had to cross from your bedroom through the dining room, through the family room and living room, to the other three bedrooms on the other side of the house.
Yes.
And before Pierce was born, Ronan was in one of those rooms, right?
Yes.
And so it's fair to say it was pretty far from your room in terms of the distance within that one house, correct?
Yes.
And it's fair to say that Ronan moved into a room Judge.
I'm kind of curious what made them want to rehear this case. It's because Florida has laws that allow it to be broadcast. Michigan broadcasts most of their cases already. It's a lot of Texas.
I have no other questions.
All right, thank you, Ms. White. Ms. Coleman, do you have any redirect? All right, you may begin.
I already have half my stuff in a pod, I could just.
Start with the layout of the house. When you talked about being able to hear some of the physical abuse that was happening,
Yes,
what room was Ronan in at that point?
in the garage.
Okay, so the location of your bedroom in the Arizona house as it related to the garage was close to the garage.
Yes,
And so you could hear the physical abuse when it was happening there.
yes,
And did you in fact see an instance where he was pressed up against the wall?
yes.
Okay. Were his feet on the ground when that happened?
I don't remember.
Okay. Did that incident scare you?
Yes.
What were you worried about?
That he was grabbing too tight, that something worse than just hurt my dad.
Okay, can you say that a little louder?
Sorry, something worse would happen than just the grabbing.
Okay, worse like how?
Are you in it? All right, stop. Let's have her restate that answer so the jury can hear it.
So what were you worried worse would happen?
Overall,
I was worried that one day, that he might accidentally,
overall,
that he would accidentally kill.
And is that based on the physical force that you saw?
Yes,
And the level of anger and aggression you saw the defendant do towards your brother?
yeah,
Is this emotional for you to talk about?
yeah.
How come?
I don't want to think about my brother not being here. It's not fair.
Now, on cross-examination, the defense asked you about were there times you made use of efforts to calm your brother down with words. What were those efforts like?
Angry, stern, not comforting at all.
Okay, is that how he was talked to and treated by both your parents, Tim and Tracy?
Objection, hearsay.
overall,
Yeah,
At the time that it was happening to you, did some of the, when you were living in the house, did you really understand whether or not what was happening to Ronan was wrong?
in Arizona,
Yeah, in Arizona.
I started
Objection as to the foundation of the question.
overall,
Just make sure you speak loudly, please.
so can you repeat it?
Yeah, at the time when it was happening, all these things are happening to your brother in Arizona. Did you understand that what was happening was wrong?
Yes,
Did it kind of, your understanding of what was happening as you got older, did that evolve?
it changed, yes.
Okay, how did it change?
It became more clear that, I'm sorry,
Take your time.
it kind of coalesced into like actual understanding of what was going on, so I could identify a word to go with it.
Okay, what's that word?
Abuse.
Now, we talked on cross-examination a little bit about some of the things that your brother did do with the family. What's the time period total that you lived in Arizona?
Again, I can't recall exactly, but I want to say like 5 years.
Okay, so over 5 or 6 years, were there times that he got to do stuff with your family?
Yes,
Over that 5 or 6 years, there were also times where he was left home alone in his room.
yes,
And times when you guys would be gone for all day,
yes,
and he would be left home alone in his room.
yes,
So those pictures that you looked at, that the defense showed you, those are all events that he some of them are as long as 5 or 6 years ago.
Yes.
And you talked about, we saw that picture of him doing homework in the house with you. Is that in the house in Arizona?
Yes.
Is that a common occurrence?
Not all the time.
Was it rare for that type of thing to happen?
It would happen if someone had supervision, so I was there. I think, I don't remember exactly, but it wasn't, I'll just say it wasn't often.
So there are times, you're not saying that the stuff that happened was when he was in the room was every single day, every minute of the day.
No.
There were times when he was outside and allowed to play.
Yes.
But most of the time, where was he?
In his room or then outside.
Now, I want, the defense asked you about, in Florida, were you reading in your room a lot?
Yes.
Do you still know what's going on in your house?
Vaguely, yes.
And you lived in the same house as your brother?
Yes.
And during the time in Florida, did you see him a lot?
Not often.
And is that because he's out of the house at school or something else?
Either at school or outside in the yard.
And then where's the only other place he was?
Room.
Now, you mentioned about how he was treated in Arizona. Was he treated the same way in Florida?
Objection. What the rule is to that?
Regarding work, yes. He was outside and in his room a lot roughly.
You talked about how when you observed your parents deal with him, that there was anger. Is that how, when they interacted with him, is that what you observed in the situation in Florida as well?
Anger or frustration.
Okay. Was there yelling at him?
Yes.
That's all the questions I have.
All right, and that concludes your testimony. You may step down. Thank you.
All right, ladies and gentlemen, that concludes the playback of the testimony of Fiona Ferriter. You may return to the jury room and continue your deliberations. All right, everyone may be seated. Court will be in recess.
Okay, we still have to finish up opening or closing arguments and then the jury instructions we haven't listened to.
Reasonable doubt is one of the earliest sort of, I guess, terms that we learn about in our civic education, our legislature, and here's why it's so important. This is a decision that is probably more permanent than every important decision you have made in your life. You will go back there as jurors, you will come to a verdict, and that will be it. If you get married, you can decide to have a divorce.
Sustained.
This decision is one that you cannot change, unlike many decisions in your regular life. And that is why we have an instruction that says if you waver and vacillate, if you think, you know what, he shouldn't have done that, I think he might be guilty, but then in another minute you're like, there was a reason for this, I think that affirmative defense applies, you must find him not guilty. If you think he might be guilty, you must find him not guilty. If you think he could be guilty, you must find him not guilty. And the one thing that I am telling you is you do not have to like Tim Ferriter and you do not have to like what he did. Because what he did was wrong. And he will have to live with that for the rest of his life. When he testified, he said, Tim and Tracy were just acting out a frantic surprise of my emotions. And he said, forgive them and move on.
Sustained.
That is his testimony. And so when you are back there deliberating, understand that Tim Ferriter made bad choices and you do not have to agree with them. But whether or not what he did amounts to a crime under the law is a different question altogether. And it is one that the state has not proven. I'm asking that you find him not guilty.
Thank you, Ms. Murad. Rebuttal? Are you going to be using the screen?
I'm not.
All right, you can go ahead and cut it off then. All right, thank you.
Defense just got up here and told you that the horrible act of parenting is not a crime. But in this case, it is a crime. Because it's about what a reasonable parent would or would not do. Because what Tim Ferriter did was not reasonable. Now, defense got up here and talked about the horrible things that he did, the dangerous things that he did, the reasons why he had to be locked up. But you have to remind yourself, these are things that he did when he was 11 years old. He is a child. He is in elementary school. Kids in elementary school will get in fights. Sometimes they'll go ahead, make jokes. He decided to go into his sister's classroom and tell the class that she was lying, made her cry. He decided to get into a fight with another child. But none of these actions amount to the treatment that he got from the defendant. Because you have to put it into perspective. These things happened when he was 11, 10. Yet when he's 14 in Jupiter, Florida, in that box, that's why. Because of the things that he did when he was 11. They talk about how the behavior was escalating. But what behavior? The lying about stealing chocolate? The bad attitude that he had when his father put his hands on him, threw him on the bed? The bad attitude that he had when he was throwing his Legos around, taking off his posters because he didn't know how to handle the trauma that the defendant caused him. That was the bad attitude that he had. Now, defense also spoke about how Dr. Rappa had records of after the fact. How in 2022 there was a neuropsychological done. But you also have to remember that this evaluation was done after the defendant had been arrested for these charges. You also get to take into consideration the fact that it is a self-reporting evaluation. That the things that Ms. Ferriter told the doctor, those are the things that she wanted to tell the doctor.
Overruled.
In light of the court's ruling of exhaustion on it.
Overruled.
Dr. Rappa also talked about that in this evaluation that there were changes, there were certain levels in his inhibition, his emotions. But she also testified that this is because of the way that the defendant treated him. She got up there on the stand and said that this is not malicious. This is just how they had to deal with it. This was the end result for them. Not malicious. Yet, she never spoke to the defendant. She never interviewed him. She never got...
I'm sorry? Overruled.
She never got the chance to find out why. And for her, it was pure speculation as to why. The biggest thing here is the criminal intent. Now, we already talked about this in jury selection. What does intent mean? A lot of the jurors would say words, actions, past behavior. And that's what the state has presented you with. We have presented you with the defendant's actions, his words, his behavior towards Rose. Because it's the intent to do these things. Under the aggravated child abuse statute, under the instruction, there's 3 different ways. It doesn't have to be each one. It's not an and. It's an or. That he was unlawfully caged, or that he was maliciously punished, or that he was unlawfully and willfully tortured. And we have presented evidence of all 3. You might go back up there and say, you know what, I don't think that they prove that he maliciously punished him. But he did unlawfully cage him. And that's still guilty of aggravated child abuse. There is also, the defense also brought up the fact that he was explosive, that he was violent. But there was no evidence of that during that 6-week period in Jupiter, Florida. If you see the videos in both the state's videos and the defense videos, he was docile. He seemed nervous around his parents. At one point in the defense videos, he's standing next to the couch while his father's watching TV. He doesn't know whether he should sit down or not. He doesn't know how the defendant's going to react.
Sustain.
But eventually, you will see that he sits there and he'll look at the father's reaction.
Objection, facts not evidence.
Sustain. Excuse me, overruled on that.
You will also see in some of the videos how he acts in the room, that he's withdrawn, that he doesn't have that stimulation. I know defense got up here and showed you January 5th. That was the big picture. He had his Legos, he had his desk, he had his bed, he had everything. But throughout each day, there's less and less and less. They try to say that this was the result of a timeout. But we all know that from Dr. Myers, a timeout is not a long duration of time. If they wanted to call a timeout, it's a timeout from January 5th, 2022 to January 28th, 2022. Again, not reasonable. Defense also brought up that this was a natural response to control the child. That if a child stole a car, what do? You take the keys away, you take the car away. And that it's not taken to the extreme. But making a child go to the bathroom in a bucket, that is taking it to the extreme. They said that they wanted to lock the door at night because they were scared of him running away, scared of him causing harm to himself, scared of all these things would happen to him. But there was no evidence of that. He couldn't even leave in the middle of the night to use the bathroom. He had to be degraded and dehumanized and use that bucket. Not only that, but you saw in multiple videos that the animals had the freedom to go around the house. Yet he was the one that was locked in that box.
Overruled. Jury can rely on their own understanding of the evidence that was presented and published to you.
In reference to the violence that the defense was talking about, there was only 2 times that was brought up. And that was in Arizona, in which the defendant's not being charged with. We're specifically talking about the time frame in December of 2021 to January of 2022. They also brought up that they had to keep in this box because it was this way. That's what they had to do. They had no other option. They had no other choice. This is what had to be done in order to protect them. But you know what else could have been done? The medicine, the therapy, that could have been done. Both experts testified that there were only a handful of times that had gone to a mental health professional. One of the experts testified that there were about 2 or 3 30-minute sessions. Is it reasonable to think that in 2 30-minute sessions, the problem is going to be solved? No. But the defendant, the solution to that is putting that kid in that box. Not trying to find other providers. Not trying to find
Overruled.
different medications that may have worked for him. But no, that was their solution. Both experts also testified that this was not the proper solution. This is not what you do when you have a child with these issues. This is not what you do when you have a child that just wants to be loved, that wants to be part of that family.
Sustain. Move on. Jury is instructed to disregard the last comment of counsel. You may continue.
There was
Ms. Black.
also a comment about Dr. Myers not watching all 21,000 videos. Yet Dr. Rappa did not watch all 21,000 videos either. And again, they went to some doctors and then it stopped. They didn't follow the advice. And again, no doctor told them.
Overruled as to that. Again, the jury is instructed to rely on your own recollection of the evidence in any determination you make.
The biggest thing here is that the crime occurred in the only space that had known for long periods of time. The state never made any allegations that he was in there 24/7. The state never said that he had never left his room. He did. But you have to also look at the fact that the only time he left his room was when there was a parent around. When they told him, you're allowed to come out. When they told him, and they would stand there and follow him out. Those were the only times he was allowed from the room. There was also times that he did not control the light. It was the defendant who would control the light. Whether it was on during the day, whether it was off during the day, whether it was on at night. He also controlled the air conditioner. You heard testimony in the videos that the defendant did not want him touching that air conditioner. Even at points where he says it's too hot, still told him, do not touch it. I know defense got up here and they started talking about the affirmative defense to the aggravated child abuse and to the lesser of the child abuse. There is no affirmative defense here because what the defendant did was not reasonable. It was not reasonable to lock him in a box. It was not reasonable to leave him in the dark. It was not reasonable to take the light away from him. It was not reasonable to leave him in the room with no air conditioning. It was not reasonable to make him pee in a bucket. There was no legal justification for any of this. And because of that, you should find the defendant guilty of all 3 counts. Thank you.
Thank you, Ms. Black. Let me have counsel approach, please. All right, so ladies and gentlemen of the jury, I know it's late in the day, and I know this has been a long trial that's already run over, but because of the lateness of the hour, I have additional instructions to read that I'm not going to read until tomorrow morning. That way you will be starting your deliberations fresh. We have concluded everything, though, at this point, so the next stage will be moving into the deliberation. So At this point, I'm going to ask that you come back tomorrow at 8:30 for the beginning of deliberations. I have additional instructions to read to you at that time, but what I don't want to have happen is me send you into the jury room this afternoon and there'll be a rush to judgment or a rush to deliberations because of the lateness of the hour. So I think the better form and practice at this point is to have you come back tomorrow. We'll start at 8:30. You should plan on, once the deliberations start, I typically go no later than 6 p.m. on most days. And if the jury's not able to stay until 6, then we usually end at 5 on days that are where jury deliberations are actually occurring. I never know how long deliberations are going to occur, but I do like to give my jurors some idea of what the normal workday is once deliberations start. So for you, then the process will be pretty much the same as it's been up to this point. Go home, relax, have a good dinner, good night's rest, because tomorrow will be a full and long day. You won't be out here in court.
Okay, so this is the jury instructions. We skipped this, and it was actually read before the closing arguments, but because I wasn't sure if they were going to go straight back and come out with, a verdict, I wanted you guys to hear the closing arguments first. So these are the jury instructions that they were given before the closing arguments yesterday morning.
All right, now that we've got the technical stuff out of the way, we are back in session on State versus Ferriter. Let me have appearances, please.
Real quick, while this is running, is there anything else you guys want to rewatch that I can go queue up while this is playing? Because when this is done, that's everything. We're all caught up and you guys have seen it all. So if there's anything else you want to rewatch, any testimony, you want to rewatch the victim testimony, anything like that, I can queue it up so we can rewatch it while we're waiting for a verdict.
Okay, all sides ready to continue with the discussion that we started yesterday afternoon regarding the jury instructions?
Yes, Your Honor, so I have made a final copy. I did my defense. It seems like we are on the same page. Everything, I took out the burden of proof for the defense. I kept it for the state.
So here's the question I have after, and I read this very carefully and looked at it probably more than I should. But I came away after reading Radford with the feeling that in this particular case where I've limited, based on the motion for JOA by the defense, to just that prong in the information that dealt with the confinement and the caging, that did not involve bodily injury and did not involve corporal punishment, I came away with the feeling that the defense does not apply with what's left of count 1.
Hold, please. Those people just walked in and they took the camera off the ceiling and put it down on the defense table. So they might be calling everyone back in. Or they're just hanging out waiting. Yes, he did testify. They didn't show him. It was just the audio, but I can play that after if you want. Okay. I thought more people were going to come in. Sorry. So I'll let you keep listening to the jury instructions, and if anything happens, I'll tell you. Maybe they're just hanging out. Well, no. Okay, something's going on. There's an attorney. The way she's shaking her head, I wonder if that's a court reporter. This had to be a very difficult trial for a court reporter. If anybody knows a court reporter, I would love to interview a court reporter. probably members of the media who do this all the time and don't take these trials quite as seriously as we do. They don't seem like they're in a hurry for anything, but they are kind of slowly filing back in. We don't have audio, though. Yeah, she was a trip. I miss seeing his streams. You missed absolutely everything. So the biggest thing that you missed was, besides closing arguments where we're getting caught up, the defense had argued trying to admit a video of the victim. After he ran away, he was caught at his school. He was on school grounds. So the Jupiter police responded to the school grounds. They located him and they took him into custody. When they took him into custody, they handcuffed him for some reason. We're not really sure what the reason is, probably because they weren't sure what was going on. You know, why was he on the school grounds when he had run away? Just for safety reasons, I would assume. They put him in a police car. They took him back to the police station, and that was that. There was media there. Somebody alerted the media somehow, which was kind of weird. And somebody took a video of that happening. The defense wanted to admit that video into evidence for the purpose of showing what his condition was when he was recovered. The prosecution argued there is many other videos, photographs, etc., that you could use in lieu of this child in handcuffs, because that's unduly prejudicial towards the child. You know, we don't show defendants sitting at the table in handcuffs. So why would we show a child that did nothing wrong and is the victim in this case in handcuffs? The judge agreed. He ruled that if the defense wanted to cut a separate part of that video out to just show the child, nothing with the handcuffs, nothing to do with being in custody, that would be fine. So apparently the defense did that, but did not delete the original video that included him being in handcuffs off the drive of evidence they gave to the jury. So the jury saw the child in handcuffs. Another thing that was interesting that I read in the pretrial that did not come in at trial, that I just happened to notice when I was looking over something, is there was some evidence related to searches on their family computer. And the mother, I think, was arguing that that should not be submitted as evidence, admitted as evidence. Sorry, I'm waiting for my second pill to kick in. I'm a little slow right now. Admitted as evidence because the child hacked the computer, and that was not accurate. Those were not her search, etc. It was somebody was scrolling through the search history and took a video of it, like with their phone, looking up at the things that had been searched. And they were saying that somebody hacked it, and that's why all of that stuff was there. Ooh, her dress a little low cut. Anybody else notice that? Why is she crying? Can we have some audio here? Maybe they have a verdict. Is that why she's freaking out? Quick verdict usually means guilty. Well, they didn't know. And think about it. You know, who knows what they were told? And the kid shows up on a school campus with everything that's gone on with school campuses and all that. I would be a little concerned as well. Oh, I should check Twitter. Yes, there's a verdict. Thank you. I don't know why I don't have Twitter up. You know, a verdict that quick. Think about it. How long were they back after they watched that video? 30 minutes? Were they just running out time in the day so they didn't have to go back to work? I mean, that's terrible to say, but I remember people talking about that. I wish someone was too, because after the defense's forensic psychiatrist testified, there was a sidebar and they brought her up and they were going through a large book, and I can only assume it was a DSM-5, and she was showing things to the judge specifically, and they moved her over like so the microphone wouldn't pick her up or something along those lines, but you could see her lips and you could see their lips, and I could pick up some of the words but not a lot of them. So I was very intrigued to see it. Welcome, welcome, welcome. I don't usually cover trials very often. This one's crazy. We're trying something new. I hope you stick around. I don't usually talk this much. People don't like my talking. My dogs don't like my talking either. But, when you're home alone all day and have no one else to talk to, it's either you guys or the dogs. So you gotta deal with it sometimes. Yeah, it does take a while to fill out the paperwork, especially when, it depends. Like paperwork I had to fill out, it was a little tiny box. When there's pages and pages and there's multiple charges, I think was the Johnny Depp, or was it the well, they got a verdict. So if you want to hear the verdict, stay live. If you don't want to hear the verdict, you might want to shut the chat off and then rewatch. One of them was like 44 pages long because of all the extra charges and the reduced charges and the aggregating factors and everything else that goes into it. So sometimes it can be really simple and it's literally a yes or no, are they guilty or are they innocent? And other times it can get really in depth and things like that. So in this case, oh, thank you. Welcome to the crew. The lesser included offenses. Yes, that's what I was just talking about. The evidence of him, the picture of him being handcuffed. That is what the jury saw that they should not have seen of the victim. So, yeah, absolutely. Which there's 3 charges here, and I think the 2 of them have lesser included. I could be wrong about that. I'm not positive. We didn't get through all the jury instructions. Let's hope, because unless there's some craziness that we didn't see, I don't see them convicting mom.
Court is back in session. The Honorable Judge Howard Coates presiding.
All right, good afternoon. Everyone may be seated.
They told him to disregard it, but once you see it, it's just like once you hear it.
All right, court is back in session on State versus Ferriter. Let me have appearances, please.
Oh. Should have done a poll.
All right. The court has been advised that the jury has reached a verdict. Are all sides ready to proceed? All right, Mark, you may bring the jurors out.
is it soft again? I have to mute myself just in case something happens. I might say 4-letter words. I'm probably already demonetized, so what does it matter? I think they instantly demonetize me. Right? That surprises me quite a bit. You should look up her website. I was pretty shocked by, like, she's got cleavage showing and everything. WTF? Yes, we have a verdict. Hold on. I should put a banner. Verdict end. I heard you did phenomenal yesterday. I appreciate the stand-in.
All rise.
Jury entering.
I like the bailiff. Right? She was hoping to get a little lunch. Side action.
All right, everyone may be seated. All right, members of the jury, has the jury selected a foreperson? And that's you, Mr. Bushy?
No.
All right,
I
Mr.
can't hold
Bushy,
you
has
during
the
the verdict.
jury reached a verdict in this matter? No, you can just tell me yes or no, has the jury reached a verdict? All right, if you could please hand the verdict to my courtroom deputy.
Penny, no.
Madam Clerk, please publish the verdict.
Everyone take a deep breath.
In the
Let it
Circuit
out
Court
slow.
of the 15th Judicial Circuit, Criminal Division in and for Palm Beach County, Florida, case number 22 CF 001136 BMB Division B. State of Florida versus Timothy Dunn Ferriter, defendant. Verdict. We, the jury, find as follows. As to count 1, we find the defendant guilty of aggravated child abuse as charged in the information. As to count 2, we find the defendant guilty of false imprisonment as charged in the information. As to count 3, we find the defendant guilty of neglect of a child as charged in the information. So we say all this 12th day of October 2023 in West Palm Beach, Florida, signed by the jury foreperson.
All right, does either side wish to have the jury polled? All right, so ladies and gentlemen, there's been a request to have the jury polled, and that simply means that each of you will be asked the question of whether the verdict is your verdict or not. If it is, you should only answer yes. If it is not, of course, you should answer no and nothing further. So, Madam Clerk, at this time, if you could please poll the jury.
Juror 1, were the verdicts as read your verdict? Juror 2, were the verdicts as read your verdicts? Juror 3, were the verdicts as read your verdicts? Juror 4, were the verdicts as read your verdicts? Juror 5, were the verdicts as read your verdicts? Juror 6, were the verdicts as read your verdicts?
Yes,
All right,
ma'am.
ladies and gentlemen of the jury, at this time, this concludes your service to your community in this matter. I want to thank you for the time and commitment that you've made to this case. It went a lot longer than I'd originally estimated. But in any event, I watched all of you during the course of the trial. You did exactly what I had requested. You stayed focused and tuned into the evidence during all phases of the case. And I hope everyone has a much better appreciation of the great responsibility that comes with serving as a juror in our community. So with that, I do want to thank you. My bailiff will give you a letter of thanks from me. Also, a certificate of appreciation from the Palm Beach County Bar Association, and a short little survey that I'll just ask that you return it when you get some time. Other than that, I do wish the best to all of you, and with that, you're excused, and Mark, you may escort the jurors out.
those jurors just preserved the lives of those children so
All right,
that they
everyone may
don't
be
go back.
seated. All right, Ms. Coakley, anything that I need to address as far as
Probably
adjudication in
brainwashed
accordance with
her.
the verdict?
He doesn't have a prior adjudication, but it is aggravated child use is a first degree felony, so we'd request adjudication at this time. We'd also ask that he be remanded into custody at this time.
Okay.
Pending sentencing.
Ms. Murat?
Your Honor, I would request that the court, as to him being remanded, he has been out of custody for 2 years without any issues or any violations of bond. If the court is inclined to remand him, my request is that the court put him on a monitor. He does have a place that he can live in Palm Beach County. He has no criminal record whatsoever, and he has no custody of any of the children.
Okay. All right, so the court, I'm going to adjudicate the defendant in accordance with the verdict, guilty of the charge of aggravated child abuse, guilty of the charge of false imprisonment, and guilty of neglect. At this time, I'm going to remand the defendant to the custody of the Palm Beach County Sheriff's Department. That's without prejudice for you to file any type of motion that you deem appropriate, Ms. Murad, for pretrial release or release during pending appeal. This ruling today is without prejudice for me to receive that and consider that at the appropriate time. Let me get an idea as to what the state is looking for in terms of a sentencing hearing.
I can do it as soon as the defense can be ready. He is entitled to a PSI. I don't know what the defense's position is as to that.
I will waive PSI, Your Honor. This is a sentencing that I should be
Come
able
on,
to
buddy.
get done relatively quickly. Should the court have time in 2 or 3 weeks?
I'll make whatever time that I have to expedite sentencing if that's what both sides request.
That's fine, Your Honor. I won't need more than 20 or 30 minutes for my presentation.
All right, so Ms. Murad,
I would need an hour to hour and a half.
so I'm going to set aside 2 hours for sentencing, and Cynthia, let's pick a date on an afternoon for 2-hour setting. No earlier than 3 weeks out. That should be enough time for you to do what you have to do, Ms. Murad, but no more than 5 weeks. So in that 2-week period there, let's pick a 2-hour setting. All right, does that date work for everybody? November 16th for sentencing
That works for me, thanks.
for the state?
1 second to get to that. Yes, you said Thursday or a Monday?
Thursday, November 16th.
Oh, I'm sorry. I'm looking at October. So sorry. Yes, that is fine with the state.
All right, so the sentencing of this matter is set for Thursday, November 16th at, what was the time, 2:30? 1:30, 2 hours reserved. All right, anything else that the court needs to address before we adjourn?
No, Your Honor. We are going to need to do a status. I know Ms. Marshall's in here. We're going to need to do a status check because I don't think we have a future date. Ferriter.
Would you do it the same day as the sentencing?
That'd be fine, if you're good with that.
I might reach out to Ms. Marshall about having something having it next week so we can get.
Whenever you want to come in will be fine with me. The morning docket, as you know, is generally pretty heavy, so one more hearing is not going to make a huge difference. Okay. All right, so then that concludes the court's business today. I do want to thank both sides for a professionally presented case. We had a couple hiccups here and there, but over the course of an 8-day trial, that's to be expected. But thanks to both sides for the commendable job that each of you did. All right, thank you. Remanded 0 bond, but that's without prejudice for a subsequent motion be filed. And if you have the orders on adjudication, I'll go ahead and sign those now. All right, so I'll remain here to sign the judgment and the adjudication. That'll be fine. So I'll remain on the bench because I have a long walk back to my courtroom, so it's better I just stay here. You can, thank you.
Oh, poor baby. Oh. Oh, they're going to fingerprint him first. They're going to cuff him. I just need to see that. Whatever. There's the link to my Discord. I put it in the description. For those of you who are talking about it, if you would like to continue the conversation there, you are. Because what she did wasn't terrible.
Yeah.
I do. It creeps me out. And I really think that he's like narcissistic, controlling. I really got bad vibes from him. I'm pretty good at fleshing that out. Yes. So what they are going to do is make a set a status hearing for hers. She was originally scheduled to go to trial sometime right around here. I'm not sure if it was before his or like next week or something like that. And they scheduled it or canceled it for whatever reason. And I think they were kind of waiting for the outcome of this. I would almost guarantee you that she ends up taking a plea deal. And you all should keep in mind that he was offered a plea deal of 2 years and turned it down. 2 years. When you take a plea deal of 2 years, you're out in like, what, less than 1? And he turned it down. That's how confident he was. And he also fired his first attorney. So, you know, I don't know. She's not really in a rush now. And I guarantee you, he had no idea he was going to be remanded into custody today because they probably figured even if, you know, you're guilty, you know, look at who you are. They'll let you go home until sentencing, which will be a couple months out. Not only is he going straight to jail, do not pass go, do not collect $200, but they scheduled his sentencing 5 weeks out, which is not that much. Lots of times it can be a lot longer than that. No, they immediately removed the children from the home. All of the children, the 2 adopted and the 2 biological were all removed. We do not know where they were placed. It just says that CPS removed the children. So mom gets to go home by herself to an empty house. So hope she has a good support system. But, you know, we talked in another stream about, I think it was the DUI stream. If one of your loved ones was in a DUI crash and killed someone, would you write them the letter of character reference? Well, what about in this situation? If you're like supporting someone through a situation like this and you believe that they're innocent, and then you're sitting in court and you're seeing all of this evidence,
More?
do you keep supporting them because they're your family, or do you abandon them and say, sorry, you're on your own? It's a rough one. Oh, his eyes are red. He knows how it feels. I think they should replay the videos of him screaming and saying that. So yes, mom did it too, but I don't think quite as bad.
All right, Ms. Coakley, I have the proposed judgment up here. This is the only document I need to sign today, correct?
Okay, they're just signing paperwork. No matter what, you know, even if she murdered someone, you
Madam Clerk, here.
move on. I'm just curious. I'm not judging in any way.
Work today. Court is in recess.
Court is in recess. Put him in handcuffs. We need that picture. Mom didn't sound as mean. If you noticed, when mom went into the bedroom to wake him up in the morning, and this was the thing that really stood out for me. When dad walked into the bedroom to wake him up, he would bark and, all right, get up. Is it dirty? You know, talking about his piss bucket. What do we call it? The shit bucket shenanigans. Now we can make a t-shirt that says shit fucking shenanigans will get you locked up. It doesn't really rhyme. We need something that rhymes. Anyways, when mom came in, she'd say, good morning. All right, get up, get dressed, go get your clothes, things like that. It wasn't super warm and fuzzy, but it also wasn't get up, like his was. So slightly in their defense, though, I would say, I guess at this point I can put a banner on the screen because anybody watching at this point knows it. They were told at some point in time that he does have this attachment disorder. So if you're told that your child is not able to bond with you, do you still constantly make an effort to bond with them? I don't really know. Because if it was important to you, you would probably be hurt by the constant rejection of the child. Oh, that's good. Oh, shit bucket shenanigans. Get you thrown in the shit can. Great. Now I'm going to get demonetized for saying shit so many times. I've exceeded the shit meter. I believe so. That was with mom, and I'm not sure who that was. I don't remember seeing that person before. And some of this could have been mom's attorneys. Like, there's no telling who it was. He's replaying everything in his head right now. Like, what should I have done different? I should have took that plea deal. What's going on? What's prison going to be like? Am I going to have a roommate? Is his name going to be Bubba? Oh, that's going to hurt. Right? I have a little bit of sympathy for the fact that they had a very difficult child. But there are so many people in the world that have very difficult children that are capable of going out and getting them the help that they need. And that was not done. If that had been done and he had tried absolutely everything on earth before resorting to this, maybe it wouldn't have been as harsh, maybe a lesser charge, but I don't know. The fact that he didn't get him help, that there were just inconsistent visits to the psychiatrist, and they were short 30-minute visits. Like, you barely even get acquainted and relaxed in that amount of time, and then you leave. And it's hard for an adult to communicate and get to know somebody in that amount of time. And I'm sure it's way harder for a child, especially one with those disorders. I hope that means you're better now. And sometimes help does work. You just have to find the right help. I have been through so many therapists in my life, and I swore therapy did not work. I swore it didn't work. I said it was a bunch of hoopla, hubbub, whatever, deep breathing. And then I found the right one that actually explained things to me and broke it down scientifically. It wasn't like, okay, just take deep breaths, breathe in and breathe out. She sat there and told me why you do that. When you're doing this, this chemical does this, and this reacts to this, and this is what happens in your brain. I was like, oh shit. Okay. So if that happens, and then I tried it and then it worked. But if you just tell me take deep breaths, I'm going to be like, yeah, whatever, go take a bubble bath. Rainbows and unicorns, here's some glitter. That doesn't work for me. Give me a reason why it works that I can look at and break it down. you know what? That too. You have to have a person, and it doesn't matter who that person is. A lot of people can't relate to their family because they're so close to them and they're worried about that judgment. Whereas when you bond with a therapist, you don't have to worry about that judgment because you know that's their purpose is to help you. Whereas you don't always want to tell your family all your deep, dark screw ups, you know? Oh, I've had some horrible ones. Horrible, horrible, horrible. One of them just wanted to talk about my dogs. She just kept wanting me to show her my animals. I'm like, yeah, my problem is not with my animals. Well, here, let me show you mine. The ugliest dogs, too. They weren't even cute. Yep. Once you get on the right track, everything is good. I could just sit here and watch this all day. That look of regret, fear. Right now, he is feeling what that child felt every time he knew he was coming. Oh my God, what's going to happen? And I hope it stays like that for a long time because he's going to go to the local jail until he's sentenced. So for 5 weeks. And then, yeah. Yeah, I don't usually ask for much, but I don't make any money on this stuff. So if you guys could hit like and subscribe or something like that, it would really help a lot. I would really appreciate it. Definitely not cute like my puppers. Although my puppers are a pain in the butt last night. So the night before last, I told you, Penny puked all over my bed all night. Clean it up. She'd puke some more. Last night, Ziggy. I don't know what they got into. It must have been something outside, but wow. Oh, come on. I can't see his whole mouth. What's he saying? He said, I know. True. Oh, thank you. Very much appreciated. But I really enjoy hanging out with you guys too. It's keeps me sane sometimes. Move your arm. You're really sweet. I appreciate the support so much. This wasn't my intended path, but you know what? I got to pay my bills, so it works. And as long as you guys enjoy it, I will keep doing it. And apparently I need to look at that trial that Cha was talking about, that the defendant freaked out in the middle of opening arguments and fired his attorney. Thank you so much. Welcome, welcome. Welcome to the crazy. We're not always this crazy. We're not always on live for 5 hours. I don't think I've ever been live for 5 hours. Holy jeez. Oh, thank you. Even though I'm a hot mess today. I gotta get some different lighting. You can't even see my hair. All that work for nothing. Hey, it's your birthday. Thank you. You're the sweetest. Yes, we have an amazing chat. We have an amazing chat. You guys are amazing. Tiff. Penny, they're being sweet. What are we going to do? Oh, she didn't even budge. She didn't even twitch a nose hair. She's like, yeah, whatever. Absolutely. I'm crappy at designing stuff. I don't know what I'm doing. I would love that. It would be incredibly thankful. Oh, thank you, Philip. Thank you so much. you guys don't have accept gift memberships turned on, I believe you can just click on where it says gifted memberships, and they will automatically give it to you. And while we're sitting here waiting for him to be handcuffed, can everyone give like some birthday love to Big Tiff Dog? Because Big Tiff Dog needs some recognition. Today's her birthday, and she doesn't like birthdays. Coffee Mom, my Instacart is grocery shopping for me right now. I'm waiting to see if there's anything, any problems. That's awesome. Happy birthday, Tiff. Tiff needs some birthday love. She said she doesn't like birthdays, so let's blow her up. Oh, happy birthday, Tiff. Happy birthday, Tiff. I hate birthdays too. Birthdays are terrible. Oh, look at how dejected he is. Happy birthday, Tiff. There you go. And you know, from what I understand, everybody's grocery shopping. The process to adopt is very difficult. Like, it's not like you just say, oh, I want a kid, and Instacart them over to your house. You know, you really have to go through a lot. And they obviously knew that this child had issues when they adopted him, because there was a report generated before they adopted him in Vietnam that said that he had this reactive attachment disorder. And that was, gosh, how many years ago? So they went into this knowing that there could be potential issues for this child. And I really think that not taking care of it when he was young and just ignoring it and hoping that it wasn't an issue is what was his downfall. Like, you bury your head in the sand, and the issue is going to grow, and that mountain is, the molehill is going to become a mountain. And then before you know it, it's out of control. And what are you going to do? And then they're scrambling, trying to fix this problem. And it was probably a case where they really wanted to hide it from everybody, because they seem like a very proud couple, you know. Image is important. So they don't want to go to therapy every week because they have other obligations, and they don't want to do all the things that really need to be done to take care of it, because money wasn't an issue. If you saw these people's house in Arizona, it was amazing. And I think right now it's worth over $1 million. Oh, thank you, Jonathan. I really appreciate that. No, I never do. And they squish all my plums too. Like, I don't understand that. Like, how do you not know not to put cans in the bag with fruit? So that is just my theory. You know, where they were living at is a very nice neighborhood, and it's got to be all about image, the Facebook thing. None of y'all are old enough to be my mama. But you can adopt me. Can I come move in and live in your basement? Man, if my homeowner's insurance goes up anymore, we can't have any more like natural disasters in Florida. I'm telling you, I have never been more freaked out in my life than 2:00 in the morning when the stupid emergency alert on my phone went off. It scares me during the day when the Amber Alert goes off, but at 2:00 in the morning when that goes off, I didn't know what was going on. Like, air raid? I don't know. That's never happened in my life that I'm aware of. I didn't even know that was possible for a tornado warning. Like, we don't have tornadoes in Florida. And when we do, they're like little water spouts off the coast. It's not like, but it was actually real tornado, and it did some damage. some decent damage. But, I mean, what do you do? We don't have basements. There's no bunkers in the backyard. Where do you go hide? I was like, well, I don't have a room without windows. I could go in my closet, but I'm just going to stay here in bed and hope for the best. Oh, it's cold there, right? That would be nice. I'll take anything that's not hot. I'll trade you. You'd lock me in your basement just to get me out of Florida. But you said it's snowing? Oh, wow. Yeah, do I get a bucket? I'm moving in with Big Tiff. We're going to have shit bucket shenanigans. Hold on. Would you say it's 56 there? It is. I bet it is 83 and cloudy. Put me in the murder room. Okay. Alaska does sound amazing. Yeah. I don't know. I've never really had to worry about a tornado. We have hurricanes here. Like, you get plenty of notice from a hurricane. Like, tornadoes? What are they doing? Like, it doesn't take this long to take someone to jail. Like, this is the whole thing. Oh, I could just sit here all day. Really, I have nothing to do. Just give me something to talk. Yeah, ladies, like, come on. Really? I don't care what you did in Arizona. We're done talking about Arizona. We're in Florida now. It's hot. It's getting a little humid in there. Can we move on? The one that went through last night, I guess maybe it didn't make its way all the way up there. It destroyed a bunch of stuff in Citrus County. Right. They actually are not doing, fun fact, they're actually not doing, oh, did they just end the stream? You just ended it? That's it? That's all there is? You're really going to just end it without the handcuffs? Law and crime, I am unsubscribing. You just ruined my day. Well. So to finish my story, they do not do body cavity searches in most places anymore. They have a machine, and what that machine is you stand in it, and it does a full body search, and it searches different layers, so it can see if you have stuff hidden in your clothes, but it can also see if you have stuff in your body. I believe we saw this in the mayor. Remember the mayor, the drunk mayor? When they took him to jail, they put him in this machine, and you have to like step up in it, and they close the little gate, and it scans your whole body. It takes like a minute or two, just to make sure that you're not hiding anything anywhere. And they don't even really have to pat you down because it's checking your clothes and everything. So, where's he at? West Palm Beach? Yeah, they probably have one. It's kind of like at the airport, but it's a little bit different. Well, hold on. I've got it up. Let me see. Body scanner for jails. A picture of it? Well, that's not really a picture of it. I want a picture. This. Although, that one says portable. Oh, there's an arrow. Yeah, this is more like it. So, kind of like this. You stand in it and then it goes through and you can see the images. It gives them a reading of it. I think there's some more. Yeah, some of these are portable. They can take them around. And then see, it gives them the multiple pictures where one of them you can just see what's in their clothes. See how you can see the shorts in this picture? And then this other one, you can see all the way through down to their innards in case they got some, you know. Oh, I can't remember what it's called. Whatever that it's called when they hide the drugs. Yeah. Anyways. Oh, what was her name? Hold on. I'll show you this too real quick. Oh, I looked it up on my phone. That's why I can't find it. Pyra. Okay, I spelled it wrong. MURAD. Yeah, I don't know why that didn't work before. Sorry. Okay, so this is the website of his attorney, which she looks really different here, and she has a nose ring. I wonder if she takes it out for court. But what makes me different? Her strength, her experience, and her courage. Where is... Okay, sorry. It's practice areas. No? Who I represent. Representing women, children, and Muslims. And women, children, and Muslims. And it talks about all of that. So what kind of surprised me is that generally when people are dedicating their practice to representing women, it's because they're in, you know, domestic battery situations, things like that, and they're representing children. They don't usually jump to the other side when they're very strong in their convictions about against domestic violence and things like that. Yeah, exactly. He had no criminal record prior to 5 minutes ago, but now he does. He did have some civil charges against him. There was some kind of personal injury lawsuit against him up north. But yeah, that's the first thing I thought is it's very interesting that she chose to defend him when that goes against the whole purpose of her practice and what she stands for. I mean, I don't know, if she was like fair and balanced and didn't really care. Yeah, like it doesn't compute in my head. Like, where is the... But then again, there's some people who it doesn't really matter what the cause is, depending on how many zeros are behind the number. So who knows? Who knows for real what it is? Yep. But you know what? I think that was probably the icing on the cake, is when he refused to let him out until sentencing, because that doesn't usually happen when there's a felony involved. If there's a felony involved, you're usually going straight to jail. You know, when it's like white collar crime and stuff like that, yeah, maybe they'll give you a pass to tie up your affairs, but he knew this was coming. This didn't come out of the blue. And sorry, Charlie, you got a wife that can take care of everything. So, no, the other attorney is still in litigation. She filed a lawsuit against him that is open, and now that he is in jail, I seriously doubt she'll ever see that money. She was probably hoping that he'd get out so he could pay her. Yeah, that's what she does for a living. That's all she does is testify, and she testifies for both sides. Like, give me the information and I will break it down and tell you what it says in my expert opinion. And generally they have a consultation first, and she'll tell them what she's going to say, and either they'll hire her or not, depending on what their side of the case is, or ask her the right questions. But yeah, that's generally how it goes. All right, everyone. Well, it is, but if you think about it, they make $350 an hour, which really isn't that much compared to what a lot of people charge. And if you see some civil cases that aren't where people are paying out of pocket, they charge a lot more than that. And attorneys charge a crap load more than that. When they're good, you get what you pay for in a lot of situations. So 350, I believe that is like a cap in Florida for what you can pay for an expert. I'm not positive, but I hear that number a lot in Florida cases. And that's what they get an hour. So when you break it down on how many hours, think of how many hours we sat here and watched this trial. And we don't have like a solid understanding of the evidence. So they have to go through every piece of documentation all the way back to, when this kid was born, every medical record, everything that they provided him 14, 20 hours worth of the Ring camera footage and all of that other stuff. So they had a ton of stuff to go through in order to develop their opinion on it. And just reviewing all of that takes time. Yeah. Which is why we don't live in LA. Right? Honey, I don't even have $12 to pay you. When I win the lottery, I'll let you know. Or one of my videos goes viral and I actually make money off of it. I just have to find that diamond in the rough. Okay, everyone. Thanks for hanging out with me. It's been fun. I hope we all feel happy from holy shnikes. I hope everyone feels very relieved to see that justice was served, because I think we all were kind of the same opinion that that's what we wanted. Justice for Dude Dad. Justice for the kid. Justice against Dude Dad? I don't know. I'm not great with English stuff anymore. I hope we all can have a good day and walk away and say, our justice system works sometimes. And it's all good. It's all good. Those kids got taken care of, and that's what matters. Okay, good. Thank you, because I didn't get it. That was his office, not his garage. Dude, you're not going to prison. You're just going to the office. Here, I got a partner for you. All right. Oh, kid's home. Have a great one. I will see you guys soon. Take care.